That was rude of me, wasn't it? I asked you for a pen, you brought it over, then I gavelled in. Thanks, everybody, for being here today. Welcome. I will call the Legislative Commission on Data Practices to order. The first order of business would be approval of the minutes of October 17th. Representative Lesch, have you had the opportunity to look those minutes over? Representative Lesch? Have you had the opportunity to look at the minutes from October? Is there any discussion on the minutes? Seeing none, all those in favor of approval of the minutes, please signify by saying aye. Aye. Opposed, same sign. Thank you, Representative Schultz. For members of the commission, staff, and in the audience, Representative Schultz is joining us via telephone. The next order of business, we will get right to it. We're going to have an overview of House File 1701. These were all bills that had hearings last session, but for reasons, various reasons, didn't make it clear through to the final, the round to become law. So a couple of these bills, there were some issues. I know members were working with stakeholders to try to come up with language that would work on a couple of these bills. So I believe that on House File 1701, neither the House or the Senate authors are present, but we're going to move forward with an overview of that anyway. Rich Neumeister is the first testifier, and then Katie Engler will be the second testifier. Welcome to the committee. Please state your name for the record and continue on with your testimony.
Madam Chair, for the record, my name is Rich Neumeister. I'm a privacy and open government advocate, and don't get paid by anybody. Do it for free for a number of years here at the state legislature. 1701 is a bill to address an issue that I think is very important for Minnesotans and policymakers to do. In order to talk about how this bill came and why, we need to take a look a little bit back in history and why and how come. First of all, we all know that government collects information about us, either voluntarily, sometimes, or coercively. And with that, they create millions and millions of files on paper, electronic files on us, individual subjects. And government entities make decisions about us, whether it be from a licensing, about your kid, or whatever it may be. Now, in 1974, when the first principles of Minnesota government data practices came around, one of the main objectives, other than talking about what is public and availability, they talked about that there are rights for individuals, subject matter people, to be able to get access to information about them. And you may have heard about that concept. It's called fair information principles, and those are part of our law. Like, for example, there are no secret records. 2, you have access to that. But one of the other major points of those fair information principle is that the individual subject is guaranteed an opportunity to find out exactly how and why data about them have been used and by whom. Not a government entity, but by whom. And that has been a standard practice of law until the last few years. So, on a paper file, your own file or whatever, your kid's file, if there was an audit law. I even remember when I was a probation worker in the mid-70s, when I had to take out some information I had to sign, it was Rich Neumeister or whatever, or when I worked for the Wilder Foundation. If you wanted to know who was looking at your file, that would be available to you on paper. But then about 5 years ago, the DVS issue came into play, where many Minnesotans' personal data was being looked upon by individuals that should not have access to that. Again, because of the law has basically stood that you have access to your own data, and you can see by whom, people wanted to know who was looking at their data. Now, they all went to the DVS, Department of Public Safety. Now, and I've had a conversation with Mr. Newton, their legal counsel. What he said, we're denying people the right to find out who is looking at their DVS data because of a law, 13.15. Now, this law was done in 2003. And the reason for that law was because people like ourselves, your constituents, were starting to interact with government on computers. And so all this data that's being collected about you when you interact with government for services, the time, whatever, that the government is collecting about you, that would have been public if it was not classified. So in 2003, the Department of Administration did an initiative to what that law is now. But because citizens were asking for who was looking at their data in a computerized file, which DVS had, Mr. Newton and the department decided to hang the hat on this law to deny people. Now, if you take that principle and knowing how those interprets become in other areas, computer files on kids, on you want to know who's interacting with your file, who's snooping in your file, who's making decisions about you, or maybe someone gets access to your own private data and then spread rumors, you'll never be able to find out if this interpretation plays itself out. And so this bill was introduced to correct that interpretation, to go back to that principle that I enunciated before, that now, if you take that interpretation on electronic files, you won't know who looks at your individual, your personal file, if it's electronically, but if it's on paper, you still can't. And that's the ultimate question here. Now, this issue was brought up, with a number of red herrings and arguments that were based on falsity. And I don't use the word falsehoods historically, but I did last year on some of those arguments. Because the arguments that were being used, if you take the time to take a look at the statute, that name would never be public. You have to recognize yourself as policymakers, that you make the differentiation yourself. Confidential. That means I can't find out who's a reporter, who's turning on me on let's say on a certain kind of cases. There's confidential throughout the statutes where you protect the identity. There's already other points of the statute that place where the name would be not available to the individual. So that's what the issue's all about. I don't intend, because you do have there's a lot more people on other bills. But I wanted to express to you the importance of this little piece of legislation. Only it adds a few words because it excludes government employees. It was never the intent of the law to include government employees under this law, to where you don't know who is looking at your most personal information that is either coerced or somewhat voluntarily given to you, and then they make those decisions about you. It goes against contrary to the principle of the law that we've had since 1974. And then you also have two divisions. On paper, you can find out if it's collected. Now remember, when it's electronically, a lot more information is being collected. So it takes away the right that is a fundamental and has been recognized in our law. So let me just share with you a little quote, if I may. And to me, when I first started coming to the legislature, one of the things, and still to today, I act a lot on principle. and a lot of quotes guide me in many things. But this is an interesting quote that I have known over the years. I know everybody's income and what everybody earns, and I carefully compare it with the income tax returns. To everybody's prejudice, I know a thing or two. I can tell a woman's age in half a minute, and I do. Yet everybody says I'm a disagreeable man, and I can't think why. This is with King Gamma and Gilbert and Sullivan's Princess Ida. So what I'm telling you is that there's a lot of information about us. People like to snoop, and there's many examples. I mean, you can point out even in today's newspapers, in the recent papers. But individuals do have a right to know who is looking at their data and using it. And because of an interpretation that the Department of Public Safety didn't want to release information, and there's a lot of issues why, and if you want to go into that, we can. From my perspective, we cannot have that, and that's why this law is so important to pass, to make sure that folks have the rights that they've been guaranteed for many, many years in the electronic age, in the 21st century.
Thank you, Mr. Newmeister. If you'd stay there, what I'm going to do is have Ms. Engler come down and speak, and then we'll open that up for questions. I want to bring members' attention to a form that is in their packets. It's from Driver and Vehicle Services. It's a Driver and Vehicle Services data request. This is one way you can fill this form out, and I asked staff to make a few extra copies for members of the public today if they wanted to grab one of these. You can fill this out and send it in to the department, and they will send you back a printout of every time that your personal information, driver's license information has been basically looked up. And you can kind of determine from there, you know, no, I really wasn't ever in Kitson County, or yes, I was in Kitson County, and yes, I was speeding. So that's a legitimate lookup. But it's one of the ways that you can find out what department has been looking up your data, but not whom in a given department has been looking up your data. And I think Mr. Newmeister's point, and the reason that I think this bill is important, is because if one agency has been looking at your data several times, it's very important to find out for what reason and who that person is. They may be stalking you. But the bottom line is they shouldn't be looking at your data unless they have a purpose for doing so that is governed by current law, and you should be entitled to find out who that person is. Ms. Engler, thank you for being here. Go ahead with your testimony.
Madam Chair, members of the Commission, my name is Katie Engler. I am an employee of the Department of Public Safety. I am here today to speak on behalf of all of the agencies from the executive branch who have an interest in this legislation. Contrary to Mr. Newmeister's interpretation, I have to respectfully disagree with him that information about government employees who access government data are public. In fact, the provisions both of the Section 1315 that's under discussion in the bill and also Section 1343 Subdivision 4, which is the personnel data section, say that data about employees who access government information are private. So what you have, or what was just distributed, is the entire section with the proposed amendment from the bill put in place so that you can see how the entirety of the section works. So, because it's really hard just to look at definitions and understand the impact of what a change in definitions might be.
Ms. Engler, this is an area of statute that addresses cookies. This isn't an area of statute that addresses who has access to my data. This addresses cookies, so.
Madam Chair, if you look at subdivision 1, paragraph A, there's a definition of electronic access data, which is separate from the definition in paragraph B, which is cookie. So this section of law covers both cookie data and electronic access data. So, and by definition right now, electronic access is when someone uses a government computer to either gain access to data or information, transfer it, or to use government services. So this is about employees who are going into databases every day to do their work, and whether or not their identity should be classified as private, which is what the law is now under Section 1315, or if it should be, as the proposed language is from House File 1701, whether or not all of that information should be public. So the provision is later enacted. It's more specific, which means any argument that a government agency would have that your direction was that the identity of government employees should be classified as private is now changed, and that includes protections for certain type of employees doing certain functions. It has an impact on the safety of all government employees. So government employees who access databases to do things like enforce public health requirements, work with tax filings, interact with people in a school about children, or with people who have a disability, to care for individuals at a medical facility that is also a government facility, to care for people who are civilly committed, to work with a Parks and Rec program. The classification of the data with respect to all of those employees would be changed based on how we understand the amendment to Section 1315 would operate. And so that's the perspective we wanted to provide to the Commission today as they take a look at the policy change that's being proposed by the bill.
Mr. Newmeister.
And that's, Madam Chair and Commission members, that's one of the issues. I see, that was never the intent of the bill. I mean, I went upstairs, you know, old hand at doing legislative research. When the bill was heard in the House, didn't have time to access for the records in the Senate. There were two people who testified. Some guy by the name of Don Gimberling, and there was some guy by the name of Rich Newmeister. Now, the tapes are being digitalized, which is great, and you, the legislature, gave money for people like me to look at, and other people, the public. But how they describe the bill as passed in 2003. Oops. It basically said, okay. Another provision will protect data collected by state websites. Information actively submitted by website users or passively collected from users' computers will be classified as non-public information to be used only for evaluating the effectiveness of its web services or for preventing people from hacking or tampering with those sites. Users must also be warned before state websites place a cookie on their computer. Cookies are used to track users' preferences and to customize the content of a site accordingly. Refusing to accept a cookie will not prohibit someone from using a website according to the law. Now, as I indicated, and for me, that was never the intent, but because the Department of Public Safety was getting lots of requests for people who wanted to know, in this particular situation, the DVS, they hung their hat on this law. I'm not aware of any other agency that if you wanted to look at an electronic file, who is looking at your file, that name would be available to you, the individual subject. This is what this is all about. Now, in paper, it's there, you can see that. And the other circumstances and whether or not you want to take the time, and there are concerns that have been, and as you know, Madam Chair and Representative Omar and some other folks may know, there are pointed answers directly to that. You can go point to point to point to point, because there are, under current law, a lot of situations. I'll give you an example. I was at the BCA yesterday, and I discussed with an official this law. Now, one of the examples at the legislative session, during which was public, they said, sovereign citizens. Sovereign citizens are going to want to find out who's looking at their files. So in discussion with some individuals on this, they said, well, under current law, you can say that's security data under 1337. Because 1337 security data, if it jeopardizes, if you feel that information not be available to you, can be denied. Well, then, and I said that, and a couple people said, well, how do you know if it's a sovereign citizen or not? So then do we take the stand that we don't allow people, parents, who want to look at their kids' files and maybe there's changes in information that have an impact, or a rumor, or on your licensing data, which is on electronic file? Do we deny people then that? See, from that angle, using the sovereign citizens as an example, you're all sovereign citizens, so we got to have this law to deny you the name of people who have access, of information. Now, the Act is a very unique kind of law, and there are some things that will be private and some things that will be public. Joe Carcetti, an old liquor licensing guy from the city of St. Paul, anyone who looked at the public file, of a licensee, he would write down the name. Rich Newmeister was looking at the file. So anybody who wanted to look at a public file, he kept track. So if you wanted to know who was looking at your file, your business file would be public. Now, or you send a letter in. So there are some things that are public, some things that are private. The legislature has made those kinds of situations and given a lot of discretion to agencies. Now, if on the DVS case, one of the reasons why, for me, why I think they denied people the ability to get the names right away, is because there was a 2-year thing. So at the end, when you found out, whenever the incident happened, a violation, the clock started to run. So a lot of people didn't have, wanted to know the name. The only way they could find out the name is by suing. And a lot of people didn't do it in enough time. Now, if they were able to have the name, they could have went to a lawyer and possibly done some things. Now, that's my own interpretation of it. But this is bigger than the DVS. This is bigger than anything else. This is about where people have a right to find who else is using their most personal data that the government either coerces or somewhat voluntarily we have to give in many ways of life. So that's basically the part of the issue. And how much you want to get into detail at this stage, it's up to you.
Let's open up to member questions for either testifier.
Madam Chair.
Senator Lemmer.
Thank you, Madam Chair. If I could direct Ms. Engler to line 1.10 on the House File 1701 bill. It's actually the existing language that's in law that I'm concerned about. I'll wait till you get to that. Page 1, line 10. We're talking about access to a government entity's computer. The data, is there data that's collected by government that may not be in a computer? And if that's true, this particular bill doesn't make reference to non-computer record or retained information.
Ms. Engler?
Madam Chair, Senator Limmer, yes, there are data that government maintains that are not held in a computer.
Senator Limmer.
And so if this particular bill went into law, that law would not pertain to non-computer recorded information. Am I assuming that's correct?
Ms. Engler.
Madam Chair, Senator Limmer, you are correct.
So there's no other provision in state statute that would regulate the use of access to a government entity's record if it was not in a computer?
Ms. Engler.
Madam Chair, Senator Limmer, depending on the circumstances, private personnel data may come into play, but if I've learned anything in the amount of time I've been doing work in this area is there is no general answer to a question. It has to be dependent on the very specific circumstances that present themselves.
Madam Chair, I think in our modern day, we kind of assume everything's in some computer record, and so we start writing laws to reflect our presumption that they are. But I'm sure there are records that, just like we had discussed, that don't use a computer to retain that data, and so this law wouldn't apply to that. So could I stretch my imagination to say that If I really wanted to keep some access point closed, just don't put it in a computer. We'll put it in a gray file box somewhere in a back room, and then there wouldn't be any access to a government entity's record if it wasn't in a computer, if we follow the way this, well, existing law is written. It's a
Anybody else?
rhetorical statement.
Yeah. Anyone else have any questions or comments? Senator Newman.
Thank you, Madam Chair. I'm not sure who to direct this question to. I think I understand what the purpose of the bill is, but what's new in this bill is language that would include an independent contractor. My understanding of independent contractors are such that the government who is hiring the independent contractor really doesn't have a great deal of control over the actions of the independent contractor other than the broad guidelines for the purpose of which they were hired. And it seems like this bill is excluding the ability of the public to find out who that independent contractor is that is looking at their records. I'm just wondering why the change to go from, the government and the government employee to now increase that to include an independent contractor. And I'm not sure who to direct the question to, but possibly Mr. Newmeister has
Mr.
a...
Newmeister?
Madam Chair, Senator Newman, again, the principle was that when the original intent of the law was, it's not to include government employees. All right? So then there was the interpretation by the Department of Public Safety that government employees will come under this. When people were asking who specifically is looking at my data. Now, the law was addressed to include independent contractors because since 2003, and with all kinds of things, there are a lot of independent contractors who, under the government function rule, are now interacting on databases, doing government's work in different kinds of situations. So it was important to cover them other than just the government employee. So let's say ABC company is doing some work that maybe government entity is not doing, you would be able to find out of that independent contractor, whoever that might be, someone in an ABC agency is accessing your data.
Thank you, Madam Chair.
Because it's no longer just government anymore. As you may know, you've seen the trend spreading out. And Madam Chair, if I just may take the opportunity to answer respectfully Senator Limmer's perspective. It's important to understand that under current law, if it's on paper and if it's collected as to who is looking at my file, I get access to that. Unless there's some other law, But if it's under this law, which has been law since 2003, and which for me raises issues in the 21st century, when a lot of our personal data is going on computer files, you'll never know who is using your data or looking at your data or doing something. And so the policy issue to you is, you want to have this bifurcated system? Or do you want to go back to the original principle of the Act, which I indicated to you at the beginning of my quote, those fair information principles, that you have and whom looks at your data. And again, the legislature, because the way we've approached data practices, have made different variations of where, no, you can't, yes, you can, through confidential and whatever. And also with discretionary laws that I used as an example of where you can say, no, you can't have that because of this. But that, again, we're getting into the weeds, but I at least wanted to share with you, I think both of us, Ms. Engler and myself, what the issue is and how you want to deal with that.
Right. Representative Lucero.
Thank you, Madam Chair. And a question for Madam Testifier. So my understanding from what I've heard you explain here is that it's your interpretation of the reading that if the data on a person is contained electronically or stored electronically and it's accessed, that that's not to be disclosed upon an inquiry, that's not in scope. And you're speaking for, as you mentioned in your opening comments, you're speaking for not just the Department of Public Safety, but all executive branch or all executive agencies. So are you also then saying that it is your position that this would be your preference as well, that data not be included as being accessible for an inquiry if it's stored electronically? Or are you just arguing that's strictly the interpretation as the law is written now?
Ms. Engler?
Madam Chair, Representative Lucerno, I'm not trying to advocate for a position. I'm trying to identify issues for you to consider as a commission as you evaluate this legislation. So maybe if I could share a couple of things in response to some comments that Mr. Neumeister has made. I, too, went back and did a little digging into the legislative history of what was happening with this bill in 2003. And I'll be honest, I could not find any documentation that indicates the statement that Mr. Neumeister made, that it was not the legislature's intent to, or the intent was to not include government employees in this language. I could find no references to that. What I do know is in enacting the legislation in 2005, the legislature used the word person, which in Chapter 13 is a defined term. And in its definition, it includes individuals. And it also defines individuals as human beings, which, based on those interpretive steps, means that the language in Section 1315, as is written now, says that no one who accesses a government database in order to do any of the steps, gain access to data or information transferred, or to use government services, the identities of all those individuals, including government employees, are private data. The language as proposed in House File 1701 would change that and say that instead of all persons being covered, all persons except for government employees and independent contractors would have their identities protected. And in fact, government entity employees and independent contractors of government employees, their identity would now be public.
Representative Lucero?
Okay, so then just one quick follow-up, similar to what Senator Limmer was asking, then the data right now that exists, that is being stored by government on Minnesotans, that's not digital, it's in a physical paper form, is it your understanding then that current law, if there's a request to see who's accessed that, if there's a way to track it, that is right now something that has to be disclosed, even if they're a government employee?
Ms. Engler?
Madam Chair, Representative Lucerno, as I explained before, the answers to so many data practices questions are dependent on the specific facts. I do think that in evaluating a request to find out who looked at a non-electronic record, the agency would have to look at your direction in Section 1343, Subdivision 4, that classifies data about government employees as private unless they're on the list of data that are public. So it would depend on the circumstances of the request.
Other member questions? Mr. Neumeister, do you want to respond to that?
Yeah, I just want to, the last thing, so.
Can Mr. Neumeister pull the mic? I think people in the back of the room are having a hard time hearing.
All right, Madam Chair. So I am a parent. I want to look at who's been looking at my kid's file, making notes in my kid's file, maybe making a statement that may have an impact. If it's non-electronic, it appears that I would not know who's making entries or focus or who has access, making decisions. But if on paper, more than likely you do, and you do. And even some recent court cases, one of them that you may hear about later on today is the KSTP case, which very clearly said that if you're an individual subject and there's data about you being in some type of process, you have a right at least to access that. This was the videotape. That principle has been around, you know, and for me, the KSTP case confirmed that since the beginning of the act. It's not just access to the data, but who is making the decisions about you. And that's the principle that you have to decide on. Not getting into all the this and that and counterpoint, but that's the decision you're going to have to reach. And I very much encourage you to bite on it, because in the 21st century, we don't want Minnesotans to have their data being used, disseminated, excised, snooped on, without them knowing who is doing it, rather than what is doing it. So I just encourage you, bite on it. You got a few weeks, a few months yet, but I think this is a very important point for what you call fair information principles. And I'll gladly send you a copy of any of that if you're interested too.
Thank you. Any other member questions? Ms. Engler, any closing comments?
No,
All right.
Madam Chair.
Thank you both for being here to testify in this bill. And members, my plan is to, in January at some point, have some meetings that just talk about our recommendations on the subject matter that we have heard over the interim here on, within the commission, so that we can give recommendations to the full legislature on several bills. So this is an important matter. And one of the principles that I try to keep in mind as I'm looking at issues like this one and the data retention piece and so forth is that government is here to serve the people, not the other way around. And we as citizens should not fear our government and what our government can do to us. And we all know that the government has a lot of information on us. And I know Senator Limmer was just sharing with me before we got started here, he was out at a conference on, I guess, big data, and talking about facial recognition and how they can identify people, and when they're walking through the airport and they lock on their face and their name pops up. Government has a lot of data on us, and with all that information comes a certain amount of power, and we don't want the balance of power to get lopsided. The citizens should be dictating to the government, not the other way around. So thank you for your time. Is there anyone else in the audience that wishes to testify on House File 1701? Oh, I'm sorry. Senator Shawn.
Thank you, Madam Chair. I just thought I'd offer an extra touch on that editorial as well. In agreement, I'd hope that we continue to have that conversation around the private companies that have our data as well, too, that Senator Limmer championed in the Senate, and I'm sure you did in the House as well, where the corporations can now just sell our browsing history and everything else like that, because a lot of this information comes through private companies that are selling and as vendors even to other private companies in stores about where you're shopping and whatnot as well too. So I think we have to continue that conversation about, you're right, the government is supposed to work for the people, and we had a lot of people that supported that last year, but we still didn't move it forward. And I hope we continue to have those conversations, and I'm going to stand with you two as well, because I know that you're champions of that as well.
Senator Limmer.
Thank you, Madam Chair. Senator Shawn, what I've known for a long time, or suspected for a long time, and it seems to be becoming clearer and clearer all the time, that government records and corporate records are oftentimes one and the same, or they're shared between the two entities. And citizens' private records go with it. And so there really is, for lack of a better term, an industrial complex that's being created by this partnership, if you will, between government and corporate interests. When it comes to intelligence communities, that really goes into a hyper speed when we get into that type of category. But so often what I've noticed is that conservative and liberal interests in legislative bodies seem to be protective of their own little bailiwick. Liberal interests might have a little more confidence in government programs than conservatives, and conservatives oftentimes think that corporations have a monopoly on virtue. And what I've begun to determine is no one has a monopoly on anything. And that either it's a matter of information for, let's say, an aspect, some type of aspect of control, or it's an aspect of knowledge in the order to make more profit. And so the sad reality is that it's racing past government policymakers because it's moving so fast with the technology and the desire to have more information for a variety of motives. But it really is up to us ultimately to protect our citizens. And I agree with you on that.
Thanks. And the one difference there is private industry usually can't throw me in jail. But government can. Government has that power that the private sector doesn't. Again, was there anyone else in the audience wishing to testify in this bill?
Madam Chair.
Representative Lesch.
I didn't weigh in, but I just wanted to thank you for passing out this form, driver and vehicle data services data request, and point out that I did this back in 2013 at the recommendation of Carly Moline, our former colleague, who was chagrined to discover how much her picture had been looked up after she got elected, which has just got to be irritating as heck. Now, I don't look like Carly Moline, and I know many women colleagues in the legislature are treated differently than are the men, and especially in light of the current goings-on with sexual harassment, I think it's all the more important for us to hold accountable very specifically the folks that are doing this. Now, I know that this one St. Paul cop, Anne Marie Rasmussen, got over $1 million from various agencies or various governments. And then there's another lawyer that was a lawyer for cops, sued for over $7 million. I don't know how much of that she got. But I would think that there's a certain point where we say, hang on a second, rather than continuing to pay out all this money from people who do not care that there's over $10,000 a pop violation, because apparently that's not stopping it, because that was in law already, and they still looked this up, and we became liable for that. That we should drill down a little bit more closely to find the specific instances of violations here, which is why this is, I think this is an important conversation to have, and I appreciate you bringing it forward. Thank you, Madam Chair.
Any other comments? All right, let's move on to House File 1316. Representative Lesch? Representative Lesch, do you have any testifiers with you today?
Yes, I do, Madam
All right.
Chair. Yeah. Mr. Ailing is here.
All right.
Thank you, Madam Chair.
Representative Lesch, go ahead.
Thank you. What I'll say, and I'll leave the nuts and bolts of this to Mr. Ailing to explain, Madam Chair, but I'd ask first, does anyone on the commission know how to surf?
Out of what?
How to surf? Now, if I had to guess anyone here knows how to surf, it would be you, Senator. I bet you know how to surf, don't you?
The web.
Okay, surf the web. Well, one thing, I learned how to surf 15 years ago, Madam Chair, and the one thing that really helped me figure out how to do it was when the instructor told me, you got to remember that the wave is moving when you're on it. If you remember the wave is moving, you do a lot better, you keep your balance, you move forward. And the interesting thing about this area of law, Madam Chair, is that it is moving really fast. And we as a legislature don't remember or recognize the fact that it's moving. So when we get cases like the one Mr. Ailing is going to bring up today, when the technology has surpassed where we're at from a policy standpoint, we run into issues and problems that don't make any sense. And we arrive at conclusions where if as in this instance of the bus camera video, if it's categorized as personnel data as opposed to on the bus, it wouldn't be public. There's something wrong with that. We need to figure out how to address this, hence bringing this bill forward that corrects that area of law. There are folks who are going to testify here today, Madam Chair, that I think it's maybe ham-fisted or too broadly encompassing of what we're trying to do. However, nonetheless, we need to get our arms around it and recognize that if we don't, the technology is going to continue to leapfrog well beyond where we're at from a policy direction. So with that, I will turn it over to Mr. Ailing.
And when both of you are finished, if you could kind of summarize what the issues with the bill were from some of the stakeholders last time, Representative Lesch or Mr. Ealing, and talk about any progress that's been made. That'd be helpful.
And Madam Chair, some folks are going to testify, I think, in, I don't know if opposition, but say they have concerns today here as well, too, so they could bring those forward as well,
Okay,
Madam Chair.
very good. Mr. Ealing, go ahead.
Thank you, Madam Chair, members and senators. Matt Ealing, Minnesota Coalition on Government Information. Most people in the committee will be familiar with us. For those who are not in the audience, we're an all-volunteer, nonpartisan, nonprofit organization that focuses on government transparency and accountability through the mechanism of public access to government data. And each year our board discusses developments in society and developments in the law that impact government data, and we come here to the legislature to help preserve public access to critical information in the face of those developments. And this bill, as Representative Lesch has noted, stems from a 2016 Minnesota Supreme Court case interpreting part of the Data Practices Act. And we're grateful for the interest that Representative Lesch and Representative Scott have shown in these issues that raise from this case. Now, the Data Practices Act, of course, is the state's primary statute that regulates government information in our state. And through that law, the legislature has reserved for itself control over the classification of government data at a state level, and it updates the law fairly frequently. Now, when courts have interpreted the act, the legislature has often reacted to clarify or to revise those rulings or to incorporate ideas from the cases into the statute. And this is in keeping with the legislature's original intention when it passed the statute to make sure that changes to the law were in the control of the public sphere, under the control of the legislature. And today the legislature has an opportunity to review this particular Supreme Court case to add some clarity that we think is deserving. So the Supreme Court opinion behind this bill was last year's KSTP versus Metropolitan Council case. It was litigated by Mr. Anfinson, who's here, who I can speak to questions about the case, I'm sure, after I'm done. At issue in the case was surveillance video on a bus requested by KSTP TV through a public data request. And that video captured an altercation between a driver and a passenger. And KSTP sought the video to investigate alleged misconduct by this driver. So under Chapter 13, the Data Practices Act, all government data is presumed to be public. That's the starting place, unless there's another statute that classifies it as not public. So in this case, the bus surveillance video, there is no specific provision of law in the Data Practices Act that would make bus video as a category not public. So that video is presumed to be public at its inception. So in the KSTP case, the facts showed that Metro Transit maintained their bus video on a hard drive. That hard drive would capture images occurring on the bus, and then it would be auto erased every 330 hours. So it would start over recording and erase what it originally captured. And that altercation that occurred on the bus was captured in this particular hard drive. Metro Transit, in this case, had also downloaded a copy of that video from the hard drive to a DVD. And they used that DVD in a personnel investigation. Metro Transit investigated the driver, but they did not impose any discipline. And once KSTP TV asked for the video, Metro Transit said, "We're sorry, we can't give it to you. It's personnel data. It's not public under the statute, and you can't have access to it." Now, if you look at your packet, page 3, personnel data is a classification in Chapter 13 that works the opposite way from much of the rest of the law. And you'll see how this works in the chart. Section 1343 defines personnel data as data on individuals maintained because the individual is or was an employee, an applicant for employment, an independent contractor, or volunteer who'd worked for a government entity. In practical terms, personnel data has been viewed as data utilized in the context of employment matters, including employee compensation, terms of employment, and so forth. Now, under section 13.43, as I've said, personnel data is not public except for an amount of public data that's set out in subdivision 2, and you'll see that listed in the box there. So if certain information is not on the list, it's not public and can't be requested by the public. So KSTP then went to court, and they successfully argued that the video from the bus was not personnel data. And KSTP noted that the definition of personnel data was inherently narrowed by Chapter 13's overall presumption of public access, and that it could not extend to the bus video simply because there's a government employee on the video, that creates a conflict and you have to defer to the public access because of the conflict. And KSTP won that argument. They won it at the ALJ level, they won it at the Court of Appeals level, and then the case got to the Supreme Court, and the Supreme Court decided differently. So their decision held that this data could have two classifications depending on the form. So in one form, on the bus hard drive, maintained for multiple purposes, they said that's public. On the DVD, in the personnel file, they said that's personnel data and it's not public. Now, the court also noted in the dicta that if the hard drive on the bus was erased and the public copy goes away, you can't get access to the same information, even though it's the very same video that's on the DVD in the personnel file. So that's how they made this delineation. So that's really the crux of the complication that flows from this case. And let me turn to the bill to talk about how that addresses that complication. So there are practical challenges to implementing this ruling, and HF 1316 tries to do that by adding specific language in the bill. Specific language would be added to the list of public data in 1343, clarifying that certain audio and video recordings are public even if they're later considered to be personnel data. And there's important reasons why this is a desirable outcome from a policy standpoint. First and foremost is a reason of clarity. So people look to the statute, they look to this book every day to determine is information public or non-public in Minnesota. So citizens use this as a guide before they make a records request. Government employees use it as a reference. Right now, the outcome of the KSTP case really isn't reflected in the statute. So the statute at minimum should have some kind of reference to what happened as a way of providing clarity. Secondly, we think that when the clarity is added, it should default in favor of public access to important government information. And it's because of the fact that the court's opinion specifically permits this bus surveillance video or similar video, it could be squad car video, dash camera video, to be classified as not public personnel data in some cases, and therefore it provides an opportunity for that video to be hidden from public view. So again, the court's opinion holds that you could have both of these copies existing simultaneously, public and not public, but if the government, for whatever reason, destroys the public copy, you don't have any recourse to get the access to the not public copy. So that's what we aim to try to clarify here in this bill. Now, while the language in the original bill deals with audio and video recordings in a general sense, if you look on the back page of the packet, you'll see a draft amendment to the bill that shows you where some of the stakeholder discussions kind of ended up at the end of the last session. Now, this language, I'd warrant, is not perfect. I think it still needs some work, but it gets to the idea of crafting language in 1343 that's dealing with specific kinds of video that we want to make sure continues to be public. So this bill is not seeking to try to take video on government employees that's currently not available and make it available. We want to make sure that what's public stays public and that personnel data is not a reason to make it not public. So that's the extent of my comments. I'd be happy to answer any questions about the case or otherwise.
Representative Shawn, excuse me, Senator Shawn,
You can call me Dan.
not here.
Madam Chair, In my question to either Representative Lesch or the testifiers, you did bring up squad cameras, so I'd like you to maybe give me some indication why you think that this would, something needs to be changed there, because we already have a pretty clear and bright line what's going to be available and not available in that realm. So please, if you could expound on that.
Absolutely, Senator Shawn. I think it was everybody's sense on the public access side of things that transit video, for instance, had a pretty clear and bright line because it's maintained for multiple purposes, for public safety, for all kinds of purposes when it's on the bus hard drive. And people had that expectation that that would be public, just as they expect squad car camera video to be public, because again, there is no specific classification in the law saying squad car dash camera video is not public. So we want to preclude problems arising when somebody tries to take that squad car video and say, this is going to be personnel data now, and it's going to disappear from public view.
Senator Shawn.
Madam Chair, sir, so are you looking to change how the designation is today? And I'll be blunt. My concern is that are you looking to make a change that we do have a space in law that gives us an opportunity to withhold video that shocks the conscience, right? And we have my crews have been working, and we've had people shoot themselves and commit suicide right in front of the officers, and it's been on squad camera, and we don't release that. Would any of your changes prevent us from holding that back?
Mr. Ealing.
Senator Shawn, our changes to the personnel data section would not affect that, because the video, if it became involved in a criminal investigation, for instance, could then be withheld under 1382 and maintained as not public for the duration of the investigation. And if there was graphic imagery, once that investigation is complete and the video is released to the public, if there is graphic imagery, some of that can be withheld under the provisions of 1382 already. So it would not change that.
Thank you.
Other member questions? Representative Lesch, would you like to have other testifiers come before you address any of the?
I would, Madam
All
Chair.
right, all right. Anyone wishing to testify? Let's see, who do we have? We have Dave Thiessen. Good afternoon, welcome to the committee.
Thank you.
Please state your name for the record and continue on with your testimony.
Good afternoon. My name is Dave Tyson. I'm an attorney with the Metropolitan Council. I'm not here to oppose or support the bill. I'm just here to make some observations on behalf of my employer, the Metropolitan Council. As currently drafted, and if enacted in its current form, the House File Number 1316 would amend the personnel data provisions of the Minnesota Government Data Practices Act. It would make the following public data: audio, video, or other recordings of government employees, independent contractors, or volunteers, unless the data is classified as not public under Section 13825, body cams, or any other applicable law. On behalf of my employer, I'd like to make the following general observations. This new provision is broad, and it would apply to a number of different types of video and audio recordings at the Metropolitan Council, which would include, for instance, onboard surveillance audio and video from Metro Transit buses and Metro Mobility vehicles, onboard surveillance video and audio from LRT, commuter rail vehicles and stations and platforms, video from park and ride surveillance and security cameras, Metropolitan Transit Police Department squad car video and audio, calls to and from our transit control center that involve communications with our bus operators and our Metropolitan Transit Police Department officers, calls to and from our rail corridor center that deal with our LRT operations, voicemail messages from government employees, video from surveillance and security cameras in areas open to the public, as well as areas like stairwells and interior areas of buildings that are generally not accessible to members of the public. And it could apply to video and audio data used for workers' compensation purposes and investigations. Now, the phrase "other recordings of government employees" is broad and it's nonspecific, and it isn't clear to me what those other recordings might be. I think the proposed amendment that is in the last page of your handout kind of addresses that. but it conceivably could also include things like GPS tracking in our government vehicles. We can tell where employees go. That would be a recording of an employee's activities. Or it could include things like my building access pass when I leave and enter a building that's owned by the Metropolitan Council. I would like to point out a couple of things for your consideration. It's possible that this proposed legislation may be inconsistent with Section 1343, Subdivision 2C, which authorizes public entities to display a photograph of a current or former employee, but only under certain circumstances. And in fact, there's an advisory opinion by the Department of Administration that says photographs of public employees are private data unless they give their consent. The other possible conflict is with Section 626.89, Subdivision 12, that makes it, that prohibits law enforcement agencies and governmental units from publicly releasing photographs of a police officer without their consent. Now, to the extent that a photograph and a video are something different, this would lead, I think, to a bit of an anomaly where you can't show a photograph of a police officer or an employee without their consent, but you can show this video of them. And again, that's probably, well, okay. And then the last thing I'd like to mention, if I can, is that House File 1316 will classify video, audio, or other recordings of government employees. The term government employees is not used in Section 1343, and in fact, it's only used one time in Chapter 13. So if I'm advising my client on what that term means, it seems like it's more broad than employees of a government entity. I don't know that that's the fact. It's in the personnel section of 1343, but it's a term that's not used in the statute, so that causes some confusion. Does it include all employees of every government entity, even those that aren't included within the definition of the statute? Does it even include legislative employees? I don't know. So those are my observations, and if you have comments or questions, I'd be happy to.
Senator Shawn.
Thank you, Madam Chair. Mr. Tyson, I think if there's spaces that the Met Council would feel very specific for security reasons or otherwise, but I guess what I might find confusing, and maybe you can help me understand it, the things that you listed as far as what you would not like to do, the communication, a call to, I mean, I can go to Hennepin County and say I want a copy of the 911 tape or a call into dispatch today. Same thing with Washington County for a call to Cottage Grove Police Department. Or, you know, you can have a political PAC. Folks have subpoenaed or asked for my emails at work to see if I'm campaigning while I'm working via city email. I mean, those things already happen, and we have to give that up. So, you know, in a polite way, I guess I'm trying to say what makes the Met Council different than the Cottage Grove Police Department,
Madam Chair.
or the city of Cottage Grove as a whole, or the city of Hastings, or city of St. Paul, or any other governmental agency.
Madam Chair. Commissioners, I'm not opposing the bill on behalf of my client. They didn't ask me to do that. All I'm trying to do is identify the sources where there is video or audio recordings of government employees, and in this case, the ones that I'm familiar with from my client.
Okay, Madam Chair, I would just I guess it kind of sounded like that so to clarify, it's not something that you find discomfort in, or what? Well, never mind. He said he didn't oppose it or approve of it. Madam Chair, I'm not going to put words in your mouth, but I think maybe you and I were probably having a little moment there of agreement, and so I'd just like to make that a public for the record, that does not happen a lot, and I'm still not quite sure what the goal was there,
Right.
Madam Chair.
Well, maybe Mr. Shetland can speak more freely.
Great. Thank you,
Mr. Shetland,
Madam
welcome.
Chair and members. I'm Judd Shetland. I'm the Government Affairs Director for the Met Council. And speaking to this bill, our purpose for being here today was really to, as Mr. Tyson mentioned, it isn't to support the bill or necessarily oppose it, but it was to point out that we do have some concerns, particularly from the council's perspective, about how broad it could potentially be be, I guess, considered. And that is something that, I know it was mentioned before, that the KSTP case, if this goes back to the KSTP case, if that's what this bill is trying to get at, what this language does in this bill is much broader than talking about the data that's available from our buses or our light rail vehicles. And so I sent a note to Representative Lesch saying that, the council was going to come and speak related to this bill, but that we just need some time to figure out exactly how does this really impact the council and our transit services, and the way we read the bill, particularly when Mr. Tyson spoke to the language that related to other recordings of government employees. We are just pointing out that we think that that's very broad. And what is this, and the way that the language is written, we're trying to figure out what in particular is the bill trying to get at, and if it's specific to the light rail and Metro Transit bus videos, that is much more narrow than language that says other recordings of government employees. And so our point is just to raise a little flag to say that we're not sure we're on board with this, but we're also not here to say that we are supportive of it. It's just more or less to say we're not sure what to think. And so I apologize for that, but we just wanted to make sure that the committee knows and that the author of the bill knows that we're just trying to get our head around it a little bit.
Mr. Shetland, did you folks testify during last session on this bill?
Madam Chair and members, I do not believe we did.
Okay, all right.
But that is one of the reasons why, when we saw this was scheduled for today, that we wanted to get on the agenda.
Yeah, I just encourage you to work with Representative Lesch to express your concerns, what you've done publicly here, but to see what we can do.
Madam Chair, that's what I mentioned
Fashion
to
language, yes.
Representative Lesch in the email.
Very good.
you.
Senator Shawn.
Madam Chair and Representative Lesch, sir, is there a different designation for Metro Transit, Met Council, related to what is a public space? Because, I mean, in my thought process, my question is, when it came down to the video and the battle for it, are Metro Transit buses owned by by a government entity or the people? And number two, are we not considering them a public space? And so what was the battle about? And I don't need to get too far into the weeds, because I know we're pushing 315 and
Right.
our minds are getting...
Representative Lesch.
Thank you, Madam Chair and Senator Shawn. No, there is no difference. What happened was it didn't actually happen in this case, because Metro Transit actually retained a copy of the public tape. But the Supreme Court said that if there was just the personnel copy left, that it wouldn't be accessible. And when that came out, we kind of said, what? Hang on a second here. We can't have that. So there was kind of no foul in this situation, because they still had the copy. KSTP got the tape. It worked out. But we're bringing the bill because if they had erased that bus tape and there was just the one sitting in the personnel file, we couldn't have access to it, and we'd end up with another blow up, about what happened. A lot of this, Senator Shawn, relates to the more high profile tapes, which relates to police action. Like, you've been in law enforcement a long time. I was a prosecutor for a long time. I was pretty sure when that Jamar Clark tape came out, it wasn't going to show anything. It wasn't going to reveal any new information. But leading up to that point, the public was screaming for that tape, sure that it was going to show something. Now, in the Philando Castillo tape, it did show some stuff to the jury that might have been helpful in revealing. There's the Justine DeMond case that came out too, but what we're trying to avoid is the public screaming about, you got to be kidding me that this is now unavailable because of a technicality. That was the original intent behind bringing it, and it was because of the personnel exemption.
Other member questions? Thank you. Is there anyone else in the audience that wishes to testify for or against this bill? Please come forward. Thank you. Welcome to the committee. Please state your name for the record.
Thank you, Madam Chair. My name is Chad Max. I work for Intermediate District 287. I'm here today too because I, not for or against, but have some concerns about the practicality of implementation of this proposed amendment. It is very unclear, it's very broad, and while the intent is clear to me now, I have to say that speaking for a school district, we have concerns. We have a lot of video cameras in our schools. We have cameras on buses, some of which we don't even own and manage. And I just want to say that, you know, we don't have enough storage and capacity to retain a lot of that, and some of this does connect to the next bill that we're going to be discussing because it relates to retention. And hearing the first testifier that was up here speaking to how the struggles and the challenges they had with the classification of the data, so that means that the retention could possibly change and be you know, a long period of time. And most video systems in school districts, you're looking at about 2 to 4 weeks, if you're lucky, of retention, and then it starts overwriting again. And with this data, obviously, there's a lot of classified data, and I'm sorry, there's a lot of public and private data that becomes intertwined in the videos. And what this does is it creates a logistical challenge and a resource issue. You have to go in and if there's a data request, you have to do the redaction. Corporations have legal teams just to do redaction in large cases. And we would certainly have a lot of data that we'd have to go through and redact to honor a data request or any type of litigation. We have a finite amount. There is no automated process to do this when a data request comes to a school district or for litigation. It's laborious, it takes a team, and there's no technological silver bullet that's going to help us do it. We're going to spend a lot of money. Just so you had some numbers to understand, I had my engineer do some calculations and cost estimations. If we wanted to increase our retention from 2 to 4 weeks to 1 year across all of our sites, and we're a small to medium school district, we'd be looking at $500,000 at high resolution, and high resolution video is what we need. That's what we value, and that's what provides value, so we can get to the bottom of issues when they arise. So I just thought that would be important for you to know. That's it.
Okay,
Questions?
thank you. Senator Shawn, I did it again.
It's all good, Madam Chair. So Representative Lesch, may clarify for a simple guy like me, because I think what I heard you say and what I heard the testifier say might not be in the same realm. Now, again, I'm not always the fastest, I'll admit that. But it sounds like I could go ask for data now to him and they would have to deal with that, whatever issues that he just brought up. Isn't your bill being specific to access to data and dealing with one specific area about personnel investigation? So for instance, if you're going to use it in saying it's protected by a personnel issue, and that's the only copy you have is due to an internal investigation, or so here's my example. The school district that you represent keeps a recording of some incident regarding staff, students, whatever it is, because there was a fight and there was a staff member intervened. Then there's the civil action allegation, whatever. It's put on a disk, a hard disk, and put in with a file. The rest of it's been overwritten, whatever it is. Representative Lesch, aren't you just saying that since it's on a hard disk somewhere, wherever it is, it should still be accessible?
So, Madam Chair and Senator Shawn, yes. So under Chapter 13, which has been on the books since the mid-'70s, this recording from a government entity is public data. Now, if it falls under a personnel exemption, and that's where it exists, it would not. This bill that I'm proposing creates a data set that states that it is public data. Now, as you know, in most instances, when we bring a bill up in data practices, we are designating a data set that is other than public. which is what we have to craft it, to make it narrower, because the default position of the Data Practices Act is public. So Mr. Max's concern is that by designating all of this as public, that they'd have to look at all these other factors. I maintain that they already did have to, but he's saying that, well, we still could have to deal with this. And I get that. And what I will say is that we are perfectly willing to work with those folks with concerns, whether it's a school district, whether it's the Met Council, or anyone else, to maybe shave the edges off of this and make sure that everyone understands. But as you know, Senator, we went through all this with the body cam debate, right? I mean, the question of storage, right? If we're creating more and more exemptions from a publicly available video to be non-public, that increases your storage because you have to create more instances, and the original entity has to retain the entire copy in order to make edits and modifications to like pixelate out faces and all that kind of stuff. But so those are all questions that we can address with them. But yes, I think you're understanding it correctly, Senator Shawn.
Any other questions? Anyone else in the audience wishing to testify on behalf of this bill? Please come forward. Thank you for your testimony. Welcome to the committee. Please state your name for the record and go ahead with your testimony.
I'm Mark Hughes, and I've been around here a long time, and I've learned a lot again this afternoon. I served 12 full years on the Minnesota State Council on Disabilities, which by state law is the most you can serve. What I've learned this afternoon is that, we're not here if we're in favor or we're not in favor of the bill. That doesn't make a difference. It doesn't make a difference what KSTP-TV thinks or doesn't think. What does make a difference is what the Supreme Court thought. And that's what won and lost the case for KSTP. Fortunately or unfortunately, however you look at it. What I'm here to tell you is this. Before you have your final hearing on this bill, before it goes into the hearing for the next session, I think it needs to be broken down. That if we look at this from the school system's point of view, here's what's going to happen. If we look at this from the Met Council's point of view, here's what's going to happen. If we look at this from the Cottage Grove Police, here's what's going to happen. We need to have this redefined more. And this discussion's been great. But all I'm saying is before you put this bill in motion, have all the I's dotted and the T's crossed. But again, I think the discussion's great. I think this is a fine committee. But I want all the sections that are governed by the bill to understand where they stand in the bill. And when hearing time comes, that the people behind the desk or the politicians understand how the bill is going to go so it can be judged fairly and voted on fairly. Thank you.
Thank you. Representative Lesch, any closing remarks, or Mr. Ealing?
Well, Madam Chair, I would note that I appreciate you having hearings on these bills because the expectations of the public, like that wave I talked about at the beginning, is moving, and it's moving in favor of an expectation of disclosure. Many agencies, whether it's a school district or police department or bus company, I was probably about 20 years ago, I went to a negotiation with Metro Transit, and every time I said the bus company, they correctly said Metro Transit. They got really mad. They didn't like it when I said that. But whether it's any of those entities, there's an expectation of the public that when you put more technologies online that capture that they should be available. And even if there are agencies that are bristling at the prospect and the complexity of like, oh, geez, you're not going to make it through this, we're the ones that are going to have to deal with the fallout from the public when we are masking or otherwise appearing to hide information that should be available to the public. And we need to have our eyes on the horizon in that way. So I hope that when we move forward in crafting these policies, we're going to set a specific path toward the horizon and what is discoverable as opposed to being more restrictive. So Nothing else. Thank you, Madam Chair.
Thank you, Representative Lesch, I appreciate it. We are now going to hear from, we're going to go on to the next bill. Shawn Rounds from the State Archivist from the Minnesota Historical Society. We're going to start our discussion on data retention schedules and House File 1185. Okay, great. Welcome to the commission. I appreciate you being here. And please introduce yourself for the tape.
Thank you very much for the opportunity to talk with you today. I realize that time is short, and so I'll keep my remarks very brief. My name is Shawn Rounds, and I'm the State Archivist with the Minnesota Historical Society, and I also function as the Secretary to the state's Records Disposition Panel. So today I'm going to focus on records retention schedules, what they are and how they function. And you have a handout that I'll go through very quickly as I talk. And I hope that there will be some time at the end for questions, but if not, I'm happy to answer questions later. So I will start by just mentioning a few of the relevant statutes relating to government records management, which I know you're all familiar with. And so on page 1 of your handout, you'll see the ones that are relevant today. 1517 is the Official Records Act. That stipulates that the records must be created and maintained by government agencies to provide full and accurate knowledge of official activities. 13817 comes in next, and that deals with government records administration. And that does several things. In one part, it defines what a government record is in great detail, and the key thing for our purpose today to take out of that section is to know that records can be in any form or media, and that's so it covers everything from paper to microfilm to digital and whatever may come next. 13817 also directs the public officials to establish and maintain a continuing records management program, inclusive of all of their records, and to establish records retention schedules. This statute also establishes the state's records disposition panel, its membership and responsibilities. And finally, it specifies that unanimous panel approval of retention schedules is required before any records can be disposed. And the basic of that is if a record is not, or a record series is not included on a retention schedule, they legally cannot be disposed of by the government entity. 13819 says that written applications for disposal are submitted to the state archivist for consideration of the panel, and in practice, those are those retention schedules that we're talking about. And finally, 13820 is where the state archives keeps the records of the panel, and these are open to the public. And this includes all submitted retention schedules, past, present, and in process, so the public can come to our office during our working hours and see all the retention schedules that we have on file. A couple things to note here when you're looking at the statutes, and this is very important, is that nowhere is there specified a mechanism or entity to provide general records management oversight. Each government agency has the discretion and the responsibility to carry out their own records management activities. Now, the Department of Administration did have responsibility for a state's records management program from 1971 until 2006, when that function was removed from statute, but there hasn't been anything to replace it. So let's turn to the details of retention schedules. A retention schedule is basically an inventory of records by record type. Its primary function is to specify the minimum amount of time that a record needs to be kept, and that's called the retention period, and then what happens to that record at the end, which is called the disposition. Retention periods are based on 4 things: administrative, legal, fiscal, and historical value. So for example, you might have a schedule that says something like vehicle maintenance records, keep for 3 years and discard. Or city council minutes, permanent, which means that it's kept in that office indefinitely. If it says something like city council minutes archives, then at the end of that retention period, when they're no longer useful to the office, they would be transferred to the state archives. You can also see retention periods that hinge on events like purchase orders, keep 3 years until audits. There are 2 types of retention schedules. There's a general schedule, which is one that covers a common record types for particular entities like cities, school districts, or a function like state agency human resources. And the second type of schedule is the agency created or agency specific schedule, which I'll get to in a minute. General schedules exist for 7 types of entities at the local level, including city, county, township, and school district. And since there is no central records management authority, these are created and updated by organizations. So for instance, the Minnesota Clerks and Finance Officers Association takes care of the city's schedule. The Association of Minnesota Counties is looking at the county schedule, and then you've got the Minnesota Association of Townships as well. Now, when these general schedules are created or updated, they are sent to the Records Disposition Panel for review. And then once that schedule is approved, all that's needed for an agency to start using the appropriate one is for them to file a notice of adoption with the state archives. If there are records that the adopters create that aren't included in that schedule, they can submit an additional schedule to cover those. In contrast to general schedules, agency-specific schedules are just what they sound like. The agencies themselves create their own retention schedules based on their own needs and submit them to the panel. The State Archives, on behalf of the panel, offers guidance to agencies online, by phone, and by email on general scheduling questions, but we cannot and we do not provide assistance with determining retention periods. That has to be based on agency expertise and familiarity with their own records. The State Archives encourages the use of blank retention schedule forms that we provide on our website, and there's actually one included in your handout so that you can see what a retention schedule looks like. The first page is for administrative use, while the following pages get into the details of the schedule, and that's where you see that they will describe a record series by type and description. There will be retention schedules, or retention instructions on how long to keep the records. And here there's one thing to note, is that a retention period is only the minimum amount of time that the records should be kept. If an agency wants to keep records longer, that's fine, but they can't keep them for less time than the retention period once that schedule is approved. So there's a section there for statutes. This is optional, but this is where, for instance, you could put a reference to data practices classifications. You can mark on the schedule if a record is vital to the agency operations. And finally, there is a column for indicating whether or not the records have historical value and should be transferred to the state archives at the end of their retention period. I want you to note here that on this schedule, format and media are not included. This is because records should be scheduled by their content, not by their format. So for instance, a paper invoice and a digital invoice should be treated just the same. Now, some agencies do choose to include format, but as a best practice, this should be only for tracking and inventory and not general retention management. I also should note here that the agencies don't have to use this form. They can create their own to suit their own needs. So some agencies will add a column that specifically addresses data practices classifications. Others will add administrative information. It really doesn't matter as long as that basic information of proposed retention and disposition for any given record series is provided to the panel so that they can do their evaluation. So before I move on to how the panel looks at schedules, there's one more records management tool that I'll mention, and that's called the PR1 form, or the one-time application for the authority to dispose of records. And there's a copy provided in your handout. Sometimes agencies come across records that are no longer created, and so rather than add these to a schedule, they can file a PR1 with the panel and get special permission to dispose of them. These forms are submitted and reviewed through the same process as schedules. They should be the exception rather than the rule to managing records. So finally, I'll tell you very quickly about how the panel does its work. The last few pages of your handout is a copy of the panel's webpage for your reference. 138.17 specifies the members of the panel as being the Attorney General, the legislative auditor for state agencies, the state auditor for local agencies, and the director of the Minnesota Historical Society. Now, in practice, each member has appointed a designee to do the routine work, and these people are listed on that webpage. Generally, the panel does not meet in person. It fulfills the function of its schedule review through a paper routing process with email communications as necessary with State Archives staff and submitters. By statute, the panel has the authority to direct the reproduction, storage, and disposition of the government records, which it does through this review of retention schedules. So in short, the process, which is facilitated by the State Archives, goes like this. Agencies that have created their own schedule submit it to the State Archives. We log that schedule, and then we review it on behalf of the MHS director for records with historical value, and we mark down which one should be transferred to the Historical Society once they're no longer needed at the agency. Then we send that schedule to the Attorney General's office, where it's reviewed for legal considerations. From the AG's office, it's sent to either the legislative auditor or the state auditor, depending on the source of the schedule, and they look it over for fiscal considerations. And then finally, after the auditor's all done, it comes back to the state archives. If it's been unanimously approved, a copy is kept for the panel's permanent files, and a copy is sent back to the originating agency as ongoing authorization for their management and disposition of the records listed on that schedule. If the schedule is not approved, then the state archives communicates with the submitter, who then has the responsibility for updating that schedule and resubmitting it for consideration. Now, the number of agency-specific schedules submitted to the panel varies from year to year, but it's generally over 100. And so far in fiscal 18, we've had 29 submitted, and that's 8 from state agencies and 21 from local government. So with that, I'm going to conclude my remarks. That's a quick overview, so I'm happy to take any questions you might have.
Thank you so much for being here, and were you the one that testified during session too?
I was.
Yeah.
There I talked about general records management in the state.
Right, and I think that was the first time that you folks had been invited into the legislature ever, right, to testify?
I think so, yes.
So this is a big issue, folks, and any questions for this testifier on how this whole operation works? If you've only gotten 29 this year, you said 29
So far, this fiscal year.
this fiscal year, okay. But I mean, how many agencies, local units of government are there that should be submitting this stuff to you?
Well, there's over 4,000, local governments, entities, for instance, but not all of them need to be submitting one. We don't need to get something from every unit each year.
Right.
Because once they have an approved schedule, that's their ongoing authority. Right. And unless their records change in some fashion, unless they're creating new record series or their retention requirements have changed, they don't need to be submitting a new one to us. And any updates to agency-specific schedules are instigated by the agency themselves. The panel does not have any oversight or authority to say, hey, it's time for you to do a new schedule and get busy and give us a new one. So it's entirely up to the agencies.
So do you think the records disposition panel in this whole process, if there's a local agency that is submitting to you a change in their retention schedule, especially if it is in regard to email at this point,
Right.
knowing that the legislature is taking this issue up, would you act on that and approve it, or would you, let me ask you this, have you gotten any requests to change?
Well, I can't speak to specific schedules because I'm not familiar with what we've gotten recently. And I can't speak for individual panel members. I'd have to defer to them for how their process works. But we do see, let me put it this way, there is no one who is charged with explicitly looking at the entirety of a schedule. So whether or not the auditor or the attorney general or the state archives looks at a particular record series is dependent on whether they feel that it's within their realm of responsibility.
Okay.
So for the state archives, for instance, we look at every record series that's on a schedule because we're looking for historical records. But we don't generally comment on whether or not a retention period is considered appropriate. And nor do we comment, or does anyone necessarily, on data practices classifications either. Just as a point of interest, the Department of Administration, until about 2002, would review schedules for data practices classifications, even though I don't think at that time they were a member of the panel. But since 2002, and certainly since 2006, when IPAD lost their records management authority, no one looked specifically at data practices classifications on the schedule either.
Okay, thank you. Any other questions for this testifier? Thank you so much for being here.
You're welcome. I'm happy to answer any questions privately.
Thank you. I'm just going to give a few notes before we go. Mr. Ealing, you can come forward, and we'll have Tony Webster go after you, and then John Ramos. I know he's here from Duluth, so I want to get the out-of-towners first up to testify. But just a little background on my bill. There's nothing in current statute, there's nothing in the data retention schedule, the records disposition panel, there's nothing in there that addresses electronic, email, basically, electronic correspondence. So what we've tried to do with this bill is define what correspondence is, and then the long and short of this bill is that I asked for a 3-year data retention schedule on email. And we just heard from this testifier that whether it's paper or digital, the data retention schedule should be the same. And for correspondence, for many of the entities that have communicated their data retention schedules to the disposition panel, they have a 3-year retention on paper documents that are considered correspondence. So that's how I got the number. When this bill was moving through the legislature, the legislative auditor also testified on behalf of this bill, said 3 years should be a minimum. And, you know, we didn't have anybody from the Attorney General's office, but I would think for legal reasons, and we do have a couple of lawyers on our commission here, that those emails could be valuable if there's a case down the road. Oh my gosh, my alarm's telling me to wake up, and I don't know how to set it this time of day, but anyway, something that got messed up. So anyway, I feel that the 3-year retention schedule is very reasonable, and you're going to hear several testifiers here today, and they're going to complain that this is going to be too expensive, and what about all these large data requests, and you know, there's a couple of things to remember, that since 1974, in the records management statute in the state of Minnesota, government entities have been charged in statute to establish and maintain an active, continuing program for the economical and efficient management of the records of each agency. It's been in place for 40 years. And so just keep that in mind when we hear folks get up and testify against having to do this. Remember also, we're going to hear from members of the public today, and we're going to hear from government, we're going to hear from associations that represent counties, cities, school boards, all these different things. And really by virtue of these associations being here, you know, it was brought up to me, well, maybe they should be looking at being subject to the Data Practices Act as well, because they're fully funded by taxpayer dollars. So again, I want us to remember that government is here to serve the people, not the other way around. And if you're going to have the technology, then you're going to have to make it available to the public. So with that, Mr. Ealing, go ahead and please give your testimony.
Thank you, Madam Chair. I have more extensive comments that I'd be happy to share with Senate members who haven't heard my testimony on this. I testified about this in the House, but I'm going to truncate my comments today in light of all the other testifiers that we have, and just speak to the mechanics of the bill. The underlying rationale for the bill that we think is important is that government correspondence is just a very, very important piece of information that the public uses, that the legislative auditor uses, that all the press uses. All sorts of folks need that information to evaluate how government functions. And so we think that the real value in having it is when it exists, and it's been retained for a reasonable period during which people can access it and do their evaluations. And so that's really the value of having this bill set out a standardized retention period for correspondence. And so in a functional sense, here's what the bill does. If you look at the very back, it sets out a retention period for correspondence. That is a 3-year retention period, as Representative Scott has mentioned. And in our packet, you'll see examples of the adopted retention schedules that counties, municipalities, school boards have generally been using. Not everyone uses these, as Ms. Rounds says, but the Records Disposition Panel and MHS makes these retention schedules, model retention schedules available. And if you look at the number of years for the retention of correspondence on those model schedules, it's 3 years in many cases. And a lot of government entities have been utilizing that. When I've spoken with folks from the city of Minneapolis, they are using a 3-year retention period for their emails and correspondence currently. So that we think it makes sense to have a statutory match with what's in the retention schedule. And the reason why the statutory need is there, the statutory change requirement is there, is that there are some entities that are cutting back on their retention of email and correspondence data. And you'll see some examples in the packet too. Hennepin County Sheriff's Office has gone down to 30 days, which really truncates the ability of the public to get access to meaningful information about what they're up to. So that's why we think the standardized retention period is useful. The bill also defines correspondence to include both electronic and written text-based information. But it also, I think importantly, has an exception in there so that there's certain things such as purely personal correspondence between, say, a government employee and their spouse. That's not covered by the definition of correspondence. And the reason for that is that that's not currently publicly accessible by the Data Practices Act. So it doesn't, I think, make sense to put it in there. And so that's why there's an exception for that information. So that's the definitional part. If you look to the front page, there's also a piece that is important for another reason. And there's an old statute, 1517, the Official Records Act, which predates the Data Practices Act by many, many years. I believe this was put on the books in the 40s. And it makes reference to official government records. And some government entities have kind of hung their legal hat on the disposal of records by saying, well, we're going to get rid of emails and correspondence we don't consider to be official because we can rely on the statute that permits that. And so official is struck from the Official Records Act and replaced with the word government. And that makes that statutory language line up with 138.17, the records retention statute. So there's uniformity and clarity there. So those are the mechanics of how the bill works. I'd be happy to come back for questions afterwards, but I know there's a lot of folks here who can testify about the importance of the retention of government correspondence.
Thank you.
Thank you.
Mr. Webster, and then if Mr. Ramos, if you want to come down at the same time and be standing by. Good. Welcome to the commission, and please state your name for the record and go ahead with your testimony.
Thank you. Good afternoon, Madam Chair and commission members. My name is Tony Webster. I'm a researcher, a journalist, and a frequent user of the Data Practices Act. I'd like to tell you a little bit about a lawsuit that I think is really the impetus for this bill and why this bill is so important. Back in 2015, I submitted a Data Practices Act request to several law enforcement agencies in the metro area seeking data about their use of biometric technologies like facial recognition. Most of the agencies had no problem complying with the request and did so relatively quickly. But the Hennepin County Sheriff's Office was very, very different. For 3.5 months, they refused to give me any meaningful updates about the status of my request, finally telling me that my request was being denied because it would take over 10,000 hours of work to perform an email search. I disagreed, but I nevertheless reduced the scope by about 90%. They continued to delay, wouldn't actually do the search, and so I sued. Hennepin County and Sheriff's Office employees testified under oath to numerous errors like forgetting to apply date restrictions, inconsistent searches, failures in communication, and so on. The judge found the search would not take 10,000 hours as they claimed, but rather 18 hours. I won an order compelling the sheriff's compliance with the law, and they began to produce some data. My findings were really interesting and show the importance of this bill's definition of correspondence. I discovered that the sheriff had used facial recognition technology for 3 years without public knowledge, and that the sheriff had used facial recognition, had conversations with vendors about using the technology for real-time face matching on public and privately owned surveillance cameras. More interesting, the Sheriff's Office asked the Department of Public Safety for access to their statewide mugshot repository so they could get more faces enrolled into their database. DPS told them no, so the Hennepin County Sheriff decided to circumvent the state, cutting deals with metro area county sheriff's offices to get copies of their mugshot databases. There are no laws in Minnesota about this technology, no regulation on what vendors can do with these images, and I only found out about it through this email correspondence. Sadly, my access was cut off because the sheriff appealed my court win, arguing that requests to access emails by topic or keyword are not valid. The sheriff obtained a stay pending appeal, allowing them to withhold access to these emails, which were public emails, until the resolution of the appeals. This case eventually made its way just this morning to a Supreme Court hearing that will likely be the most consequential Data Practices Act access case in recent history. I tell you this background to establish a few things. Emails and other forms of correspondence are really important to understanding what government is doing and how taxpayer money is being spent. It is, as this bill would define, documentation of decisions, business, and functions of the agency. And by the time I see these emails, it will likely have been 2.5 to 3 years since I requested them. If I find out at the end that the original search was never sufficient, those emails might be gone now. I say that because last year, after my case reached the Court of Appeals, a source leaked a memo to me which ordered all sheriff's office emails would now be automatically deleted after just 30 days unless it was manually flagged for retention. I had never heard of such a short retention policy before. There was no announcement, public hearing, journalists weren't told, it just happened. I passed around the memo, which was verified and reported on by the Star Tribune, Pioneer Press, and others. Hennepin County followed shortly thereafter with a 6-month retention policy with instant messages now being deleted after just 24 hours. And now we have this bill, and it would require a 3-year minimum retention policy on correspondence. I think that's very much needed. Last session, I submitted written testimony that I was concerned that government adopting a 30-day retention policy was far too short, and that government delays, errors, or how long court proceedings take to resolve, data will go missing. And now I can report to you that that's exactly what has happened. Unrelated to my lawsuit, I submitted a new data request last year to Sheriff Stanek's office. I sent the request on November 23rd, but they did not process the request until December 9th. This 16-day delay in processing the request compared against a 30-day retention policy meant that the email sent between 30 days before I sent the request and 30 days before they processed it had all been deleted. These were emails responsive to my request, deleted by automatic process before they could be produced to me. I'll never see those. Of course, they never came out and told me this. It wasn't until about 10 months later, after numerous inquiries, that they finally admitted that those emails were gone. The emails I was able to see included big contract negotiations, exchanges of plans about major initiatives, and discussed significant events like the Super Bowl. But prior to that short period of time, they just didn't have really any emails or very few emails. I think back to like research projects I did back in college, and where I'd find letters from the late 1800s that had been preserved as important artifacts of history. But today, government runs on email, business runs on email. It's become the mechanism by which government operates and a journal of everything government does for its people. But in a time when storage is cheap and technology options are many, we're deleting this history after just 30 days. The way I see it, government associations are looking to curtail the Data Practices Act in any way they can. From their perspective, reducing retention time might be the most ingenious way to do it, because if data does not exist, it can't be requested. If data doesn't exist, any lawsuit to enforce compliance is moot from the beginning. To Madam Chair's point about government associations, I thought it was interesting in the Supreme Court hearing from this morning that many government associations lined up to file an amicus brief where they asked the Supreme Court for case law on a number of things this legislature has not given them over the years. It's frustrating to me in the case of the sheriff that they can spend hundreds of thousands of dollars on high-tech surveillance technology, but searching email, saving email, that's too difficult. The defense I usually hear from government is burden and cost. And I am very sensitive to the fact that oftentimes government resources are stretched thin, which is why it's really important for government to adhere to existing statutory requirements to keep data easily accessible for convenient use and to have procedures to ensure prompt compliance. But in my experience, some agencies haven't put much thought into those statutory mandates. Last year, I sent a data request to every county in the state. It was very simple. I'd like a copy of your Data Practices Act policies, the one the law requires you to have prepared and updated on an at least annual basis. Now, some agencies did a great job and responded quickly, but a year later, I'm still waiting for some of them. Some agencies actually drafted the policies solely because I requested them. Many agencies had policies that were several years old, and many were older than a decade. The city of Duluth is still using a data access policy from 1995. If government hasn't thought about how to efficiently manage their data and how to easily facilitate data requests since the earliest days of email, that seems to be where they should focus. It's impossible to comply with a law if you haven't thought about doing so in advance. That's a key point in numerous advisory opinions from the Commissioner of Administration. But I guess it seems easier to just not have and to delete the data. Compound that with the fact that government frequently has insufficient policies with these short 30-day retention schedules, and it's a big problem. The Official Records Act requires government to currently make and preserve all records necessary for a full and accurate knowledge of their official activities. When correspondence is deleted automatically after 30 days, and individual government staffers without any knowledge of the law are solely responsible for making decisions about what to flag for retention, emails and correspondence will be deleted without any recourse for the public. This bill helps solve that problem. I view 3 years as a minimum. The justice system moves really slowly. We often don't find out about controversies until months or years after they've happened, and timeliness is a frequent problem. For example, when I asked MNsure and the Minnesota Department of Human Services for records on how long health insurance consumers spent on hold to talk to someone, MNsure took a couple months, and 10 months later, I'm still waiting on the other one. I've been waiting 2 years for records from other agencies. I recently heard from another sheriff's office who I asked for some emails, and they took about 2.5 months to get back to me. And when they sent the invoice, they said it only took 2 hours of time. So timeliness is an issue, and if we're deleting emails before that, it's a problem. There's no shortage of discussions that need to be had about data practices, but the reason I see retention at the center of all these issues is because in order for there to even be a discussion, there has to be data. Data has to exist, and right now, some in government have decided the best way to stop having these conversations is just to eliminate the data. I also think from a good government operation, how can you effectively run government, do HR investigations, battle civil suits, handle zoning disputes if what you work on every day is gone unless you as an employee who might not be aware of the law remembered to flag that email. And I think for the vast majority of government employees, they get so many emails fly by, they forget to flag something, and it's just gone. So I'd ask you to please, don't let government, delete data and emails, correspondence whenever they see fit. I think instead it's important to ask tough questions of government about their policies, their procedures, their technology procurement decisions, rather than just accepting an argument that destroying data is the only solution or that it's in the best interest of taxpayers. Deleting data before anyone has a chance to even think about requesting it defies the legislative purpose of the Data Practices Act and negates any enforcement mechanisms in the law. 3 years at least gives the public a chance to use their right, and it's my hope that House File 1185 becomes law. I appreciate the opportunity to testify, and I'm happy to answer any questions.
Thank you. We're going to have the other testifier go, and then we'll open it up for the questions for two of you. Mr. Ramos, please state your name for the record. Thank you for coming all the way to be here.
Thank you, Madam Chair. My name is John Ramos. I'm a reporter with the Reader Weekly in Duluth, and I'm here to speak in support of House File 1185. In 2014, the City of Duluth hired a consultant to conduct an objective evaluation of the condition of the Duluth Public Library and make recommendations for its future. In their report, the consultant said that a full renovation of the existing building would cost $31 million, and to build an entirely new library would cost $35 million. At that point, everybody began talking about building a new library. The problem was that the report wasn't objective. As I discovered when I looked at internal City Hall emails, the administration had been conspiring behind the scenes with the consultant almost from day one to write a report that pushed the mayor's preferred option of building a new library. There was a reason the two top price tags came in so close together. The renovation cost was overestimated, and the price to build new was lowballed. Even as the mayor was saying publicly that he hadn't made a decision, he was in discussions with the property owner downtown for a new library site. Architectural plans were already being drawn up. When my story came out, however, all the planning stopped. It has never resumed. I think it is fair to say that my article saved the city $40 million by preventing an unnecessary new library from being built. To write this story, I depended on almost a year's worth of internal City Hall emails obtained via data request. Without them, I would not have been able to find out all the Machiavellian maneuvering that was going on behind the scenes. People certainly weren't going to tell me. As a matter of fact, at one point, the emails showed top city officials discussing among themselves how best to keep me in the dark, me personally. Since that time, I have done 3 more large data requests for emails. All of them resulted in substantial stories. As with the library, I discovered that what the administration was saying publicly was often different from what they were saying behind the scenes. They often already had a goal in mind, but held stakeholder meetings and solicited public input to establish an illusion of transparency with which to legitimize their plans. In short, internal governmental emails are a fantastic way to find out what's really going on, far superior to interviews, in my opinion. In the interest of transparency, I support the 3-year retention schedule. Thank you.
Thank you. Any questions for these 2 testifiers? Representative Lesch.
Madam Chair, thank you. And I preface this by saying, Mr. Webster, thank you for, I've tracked what you've done here in the Twin Cities more closely, so you're dogged about this, and that's impressive. And I think this area of law, I would say, has probably, I don't know, per capita as many citizen advocates as maybe education, which is really what creates better policy. But I don't know if you said this. If you did, I missed it. But the 3-year component, was that in any way arrived at in analyzing best practices in other states?
Mr. Webster?
Madam Chair, Representative Lesch, I don't know how that specific time frame came up. I know that there were some discussions about, shorter lengths and personally, I thought 3 years was kind of a minimum based on how long, my litigation was taking. So I guess I'm not familiar with other states and what some of their retention schedules are or how the specific bill was formulated.
Well, and
Representative Lesch?
Madam Chair, and maybe, I don't know, is anyone going to come and testify against this? Are people going to come up and testify against this?
Oh, yeah.
Okay, well, I'll wait for that then. I'll wait to ask some questions about
But
that.
Representative Lesch, were you asking where we arrived at the 3-year in this bill?
Well, I was just asking, Madam Chair, if it was, how does it compare with best practices in other states? Like what's working for them north or south of 3 years, wherever they're at?
Well, we now have an employee researcher that can look up that information for us and compare it to other states.
Okay.
But I got the 3 years because in many of the retention schedules for local units of government, the paper correspondence retention record was for 3 years. So that's how I arrived at it. Paper or electronic, to me, doesn't make any difference
Well, if I could,
for the same amount of time.
Madam Chair, maybe ask those folks that are going to testify against it if they could say, the amount of space that written correspondence gobbles up as compared to image, and maybe some of this stuff is imaged, I don't know, let alone video is minuscule. So if they're saying, hey, we have a problem with the amount of storage, I'd like to hear their explanation of that, if there are certain assumptions that go into that.
Thank you. I believe Ms. Pontius had a comment regarding what the default mechanism is for data retention.
Yeah, Madam Chair, I think that the 3-year comes from the sort of the default rule, the model policy that applies to government entities, so that's where that was picked up. Now, obviously, entities can do their own schedules, but then they have to go through the approval process. Then you have the side issue of what an official record is that would come under that model policy.
Right, all right, thank you. Any other questions for these testifiers? I really appreciate you being here today and for the work that you've done to keep government accountable, and thanks again for being here.
Thank you.
Thank you.
Next up, Rich Newmeister and then Chad Maxa. No. Oh, Rich is saying no. Mr. Maxa then and Mike Funk. Welcome back to the testifiers table. You'll need to restate your name for the record.
Thank you, Madam Chair. My name's Chad Maxa with Intermediate District 287. And
Where is 287?
it is in Plymouth.
Okay, thank you.
Yep. And so today I wanted to, initially I'm just going to respond to Representative Lesch's comment. I agree that email doesn't necessarily consume a ton of space, which is why I think most districts have just found it easier to go ahead and just stick with it, a minimum of a 3-year retention period, and most have that boilerplate records retention plan in place to do that. Obviously, technology has come a long way in that area, and I don't really see that as an issue. In fact, I agree that we should have something in writing and in law about this to kind of standardize that. There's no doubt about that. The concern here, though, again, too, that I have, that I just want to bring forward, and we're happy to implement this and work through this with you. Just want to note that we are also accountable to the taxpayers, and from history, when we started with paper to where we're at now, we're managing paper and we're managing digital records. And now that with the proliferation, just the ubiquitous nature of smartphones and all these, the Internet of Things and all these devices connected to the internet, so easy to generate, mounds of data every single day. And what we've done here is, it appears is that the term records does not exclude data and information that does not become part of an official transaction, to kind of get at that transparency, I'm assuming. What this will do is it will increase the burden and the cost, because we are going to need more time, more labor to go through all of the information. We'll have a lot more of it now that we'll have to retain. It also creates questions for us about drafts of information. So being a school district, we have a ton of IEPs, individualized education plans for our students. And as it stands right now under the Minnesota Government Data Practices Act, those aren't maintained, and so that we don't have to address those. So it's a significant change in terms of the definition of individual data, and so there would have to be some clarification in the Minnesota Government Data Practices Act around that. Now that, correspondence, this has broadened the definition of correspondence as we knew it in Minnesota Statute 13.601 subdivision 2. And as I stated earlier, most entities are developing their own schedules, but school districts have adopted the general retention schedule from, I believe, the state archivist office. And so, again, most have that 3 years of correspondence, and we don't just do administrative correspondence as what's called out in most. We do it all. And you could speak to a number of the bills we've talked about today. The sheer volume of data makes it impossible for us to classify all of it. It doesn't happen. So what happens is we just keep storing it, and it grows, and then it becomes a very challenging beast from a technical standpoint to manage. And then when you have to perform e-discovery, if there's litigation or an investigation or things like that, it just becomes more time consuming. So again, I would just add that I think this, to summarize, this really puts us in a position of, well, we just have to store everything forever, or it's very difficult to make these classifications. So thank you. Questions?
Well, let's hear from the other testifier, then we'll open it up to the both of you, if that's okay.
Thank you.
We'll kind of go into this today. Go ahead.
All right, thank you, Madam Chair and members of the committee. My name is Mike Funk, and I am the Assistant City Manager of the City of Maplewood. For those that are unfamiliar with Maplewood, we're a community of 40,000 and located just first rig suburb of St. Paul, and we border certainly a number of other communities in Ramsey County. With me this evening, or behind me, is Irene Gao from the League of Minnesota Cities, and I'm here representing cities across the state of Minnesota. So not only just Maplewood, but certainly cities in rural parts of the state, as well as many of our metro partners as well. I recently was the chair of the Data Practices Task Force for the League, and the Data Practices Task Force met here a few months ago. We did have Representative Scott attend one of our meetings, and we discussed this with many of our members from those cities, many different facets of city government. On that 40-member task force, we had not only people like myself that were city administrators or city managers or assistant city managers, we had other folks from city administration, records management, public safety, so we did have representatives from law enforcement, information technology, human resources, as well as city attorneys, so from the legal as well. Those members came together and we met twice really to, again, discuss what does data practices mean for cities across Minnesota. And before I also want to comment on Representative Lesch's question, but before I probably state that we are here today testifying on behalf of the League of Minnesota Cities in opposition to House File 1185 or Senate File 1719. We do appreciate your time in studying this issue because it is complex. Again, from our perspective, it's extremely complex. And I hope to provide additional context for records management laws and how cities address correspondence today. If I could just, before I go through some of my other prepared comments, maybe talk a little bit about city government and my experience in city government. I've been a city manager for 20 years and have worked in 4 different communities in this state, starting from outstate Minnesota, a small town called Olivia, worked in Minnetrista, and now find myself with the city of Maplewood. So I've worked in smaller communities as well as larger communities. I haven't met my fellow testifier today, but I would echo a lot of the comments that he made in terms of the challenges in managing data. And most of my comments are going to be about how we balance the need to manage data, because I would agree that government is accountable. And I haven't found a city personnel, someone in my position, or even council members that would disagree that government is accountable to our constituents. In fact, open government is important and essential to the accountability aspect of how we manage our daily affairs. There is, however, a balance that's needed in how we accomplish that, because as the gentleman next to me stated, that there is large volumes of data that's collected every day. We're an organization of 170 employees working out of 3 different facilities, and every day we have, of those 170 employees, emailing, and whether it's project files, project data, payroll, accounts payable, accounts receivable. The challenge isn't necessarily about how we store it. That's just one aspect of it. And it's more about the format in which we store it, how we collect that data from every department, because we have multiple departments, whether it's public works, public safety, community development, the human resources office, finance department, and I could go on with naming other departments, but I hopefully get the sense that working with a community of our size, and it really doesn't matter what size of government you're in, they have different departments. So the challenge within all those departments is not only the amounts of data in the logistics of maintaining that data, but then how do we collect that and create a central clearinghouse? That has been a challenge. And I think that's a challenge for every city that you would visit with, is knowing that we have data in different departments, different locations, and then how do we then store it in the correct formatting of that? I remember years ago, at least as a kid, you go to school and they had the old Laserfiche, and you could pull up things with a big screen and you'd shove the, move the handle around and you could look up things. That's changed, and the technology certainly has made it easier today to store that kind of data, but the format in which it's done makes it more difficult. And so even for us, that we have a full-time data practices person trying to accommodate requests, the amount of time it takes to pull data from different departments, working with different department heads, the different formatting that it's in, the types of records that it is, whether it's paper, email, video, audio, does become consuming. So with that being said, hopefully that provides you a little more insight, Mr. Lesch, on your question in terms of,
boxes and boxes of paper that we used to have, filling up rooms and storage down in the basement of city halls, trying to convert that to some sort of electronic database. There are different software applications out there. Those take money. It takes a lot of money to purchase those software, and then how you store it's another expense, whether you're storing it in-house on your own servers or you're buying space versus cloud storage. So I mention all that just trying to put into context some of the challenges around managing it and trying to fulfill data practice requests. My comments, I'll try to buzz through the rest of my comments here because I know you have other testifiers. Records management laws and their corresponding records retention schedule balance the public's right to access government information with the maintenance and management leading up to the purging or the destruction of records. The balance of these values is important. Cities are currently required by law to maintain a full and accurate record of all city transactions and affairs in the city general record retention schedule. And that record retention schedule has 29 categories and almost 700 specific records. These records need to be kept for a specified amount of time, regardless of the form. For example, and this is not uncommon, when a resident complains about a neighbor's property, which happens, that complaint, whether it comes by email or letter, needs to be kept for 7 years. Recently, there's been in the news, email retention policies make it seem that all emails are deleted after some amount of time. That isn't true. Under current law, if an email is a record, it must be kept. These policies only address emails that are not concerned records, but are considered transitory in nature. So those are the ones that are being deleted. So such as scheduling or confirmation of location and times of meetings, so some of the non-ancillary types of emails. With the example I just gave you with the resident complaining about a neighbor's property, again, if that complaint was emailed to the city, we're required to keep that for 7 years. The city's record retention schedule distinguishes correspondence into 3 categories, and I think some other previous testifiers had alluded to this. One is historical, which means that records must be kept permanently, and includes correspondence to and from the mayor, the city manager, or the city administrator. The general schedule points out that this includes official correspondence documenting important events or major functions of the office. It also usually deals with specific topics, issues, organization matters, or individual matters. The second category is messages, which is required only to be kept until read. And this includes transitory messages, emails, social media, phone messages of short-term interest, which are considered incidental and non-vital correspondence. The city's record retention schedule specifically notes that transactions of city business should be kept in accordance with the applicable category under the record retention schedule. And then the third category is general. Again, this is someone, I think this is already alluded to, which must be kept for 3 years. There is no description of what general correspondence is, but it'd be really kind of other, it's something that falls into the other, what doesn't fall into the other 2 categories that I mentioned, either historical or messages. In closing, we appreciate Representative Scott's excluding some personal communications, announcements of social events, and unsolicited advertising of correspondence, which is somewhat similar to messages, as I just discussed. But cities are still concerned about the broad scope of this bill. There are many routine tasks that are accomplished in written or electronic text-based communications that provide the public much value, but would be administrative and financially costly, even so in addition to what the costs are today. And anecdotally, I can say that in my 20 years of government and working through 20 budgets in the last 20 years, I have not met a council member that isn't concerned about expenses or taxes. And I think the same folks that are concerned about open access to government and adding these types of burdens to cities are the same folks that also worry about the cost to government. So that's where, again, I think balance is critical in these conversations. In addition, this bill would be an unfunded mandate, and it would require cities to keep many more records that may have little or no public value, both generally and regarding correspondence. I appreciate your time this afternoon, and I'm here and available to answer any questions that you may have. Thank you.
Member questions? I have a question to both testifiers, and that is, do you use an email archiving system? Both are nodding their
Madam
heads.
Chair? Yes, we do.
Okay. And how long have you had that in place?
We've had an archiving system in place since 2008 when I arrived in the district.
Yeah, Madam Chair, I don't know the specific year that it was installed. I've been with the city of Maplewood for 3 years, and we've had it during that time.
Okay, all right, thank you. One of the things that occurred to me when you're talking about all the different departments that you have within your city government, and I leaned over to my conservative friend next to me here. I said, maybe this is, if we had smaller government, there'd be less data. So maybe that's the solution. Maybe we have just smaller government, right? Fewer departments and all that stuff. But any other member questions? Thank you for your testimony.
Thank you.
Thank you.
Next up, let's see, is Keith Carlson and Lori Beyer. Keith and Matt Hilgert are coming up together, representing the counties. As you can see, we're over time once again, so if you could keep your comments precise, that'd be great. Thank you.
Thank you. Madam Chair, members of the committee, thank you for the time today. My name is Matt Hilgart, and I work for the Association of Minnesota Counties, and AMC represents all of Minnesota's 87 counties. My colleague next to me, Keith Carlson, who represents MICA, will delve into some of the more details, but I'm going to take a more general approach, and I'll try to keep it under 2 minutes. As everyone in this room is well aware, Chapter 13 is not easy reading, nor are the processes for keeping data, disposing data, and separating public from non-public data. And I'll preface my testimony by saying, to the extent that counties can better communication, ease of access, and general customer service when dealing with data practices requests, we are sincerely interested in that endeavor. Specifically regarding House File 1185, the most frequent concern I hear from elected county commissioners in your districts, whether it be Anoka, Washington, Wright, or Ramsey, is surrounding cost and government efficiency. As members are acutely aware, the legislature is continually asking local governments to keep property taxes, levies, and government spending low. In fact, there's even an editorial this week that's been circling local papers around the state that we're hearing from, which is saying, we're a member of a committee here saying we're watching levies and we're acutely aware of whether they're going up or down. So what's often overlooked is the acute complexity involved in keeping tax burdens down in an age of increased demand for services and dwindling state and federal support. A 0% levy could change overnight when employee health insurance premiums go up 20% in 1 year, which some folks in this room are absolutely cognizant of. When something as unpredictable as budgeting for child protection costs multiply by 4 or 5-fold, or when the legislature passes down new mandates or cost shifts, such as many of the counties in this room are dealing with min choices. This is all to say that we are acutely aware of the intricacies and challenges that go along with property tax increases. House File 1185 would absolutely cost local governments money. And as currently written, it is an unfunded mandate. To that extent, we would ask that the legislature take the shared sentiments I've just stated into consideration and identify resources or aid, or even create mechanism to balance the expanded scope of staff time and costs associated with this bill. Watching this bill throughout the last year continually reminds me how complex and impassioned this issue is. But in my humble opinion, nothing as impactful as House File 1185 is black and white. And to illustrate this point, I'd close with a remark from Judge Larkin, who was involved in one of the cases that was mentioned earlier today at the Court of Appeals with Mr. Webster versus Hennepin County, where the judge said, "We are cognizant that the nature of government data has evolved and expanded in recent decades. It may be that the time is right for a reassessment of competing rights to data within the context of effective county government, or government operation, sorry. And no matter what side you may currently fall on this issue is complex. And to the extent that the author and members of this committee are interested in finding reasonable, practical, or a compromise approach, we are extremely interested and willing to be involved. I'd close with just thanking the committee for their time.
Thank you. Mr. Carlson?
Madam Chair, thank you. I'm Keith Carlson. I'm Executive Director of the Minnesota Intercounty Association that consists of 14 of basically the regional center and 4 suburban counties. I'll try and get through this as quickly as possible. I do want to make it clear the difference between records retention and data practices, as the committee knows. Records retention is what we have to maintain to document our official business. It's the only thing that has been reviewed by a third independent party that it's adequate to meet our legal, financial, and provide adequate historic documentation of our official business. Data practices obviously applies to everything in our hands. House File 1185 obviously goes far beyond this and requires retention of all records, not just the records necessary to preserve full and accurate knowledge of our official activities, and requires the retention of correspondence, including electronic text-based communications, for 3 years. It's already been covered by the cities, but I think, again, it bears repeating that I believe the city schedule, where this 3-year standard came from, provides that transitory messages, including emails, have to only be retained until read. That's vastly different until what this bill provides. And I'll also speak to the issue that somehow the current law doesn't speak to computerized records. Chapter 15 specifically references computerized records. I think, has already been covered. It creates a logistical nightmare for us above and beyond the one that we suffer right now. Correspondence could be, that we would have to retain, would be Post-it notes, other pieces of paper, which we don't even have adequate means to capture right now. It includes text messages or transcribed voicemail messages that never touch our systems right now. Somehow we would have to figure out how to capture and retain those messages. This raises substantial personal privacy issues for our staff, because in many counties, we don't own the smartphones that they use. We instead reimburse them for use of their personal phones for conduct of our business. Consequently, both personal as well as business-related text messages would be available, and somehow there's just frankly no way for us to distinguish between the two, so we would be retaining both and possibly be compromising their privacy. Substantially broadening the scope of the records to be retained is not easy. It's not a matter of putting the data on a thumb drive. It's not a matter of acquiring software that's used by the private sector, basically for litigation holds. Government data requests are completely different in that, one, any records that are retained must be reviewed and not public data redacted before it's turned over. And that's a manual process that requires the skills of somebody knowledgeable in data practices, usually an attorney. And also we have to cover, particularly at the county level, multiple lines of business. We don't have any one system where all records are retained. The substantial broadening the scope also breaks with what Ms. Rounds touched on in her testimony. The current status for data retained is its content, not the media. What the House File 1185 says, regardless of what the content of an email is, we have to retain it for the 3-year period, as well as other correspondence that meets the criteria in the bill. Substantially broadening the scope of what has to be retained is obviously an issue in our storage costs, but the much larger issue is review and redaction. For example, the issue that was raised in the Webster case with Hennepin County would have required the county to search all 209 million emails that exist within the 8,000 employee email accounts that exist currently within. That's not something that you can use their email software, Outlook, to do. It required separate computer forensic software to do it, and was estimated to take 29 days just to pull out the relevant emails that's before the review and redaction would be required. By way of comparison, I made a request of the legislative auditor for two correspondence relating to two investigations that their office did that generated 140 documents. That took them 4 hours. It wasn't a matter of pressing a button, doing a search that generated. It still took them 4 hours, even though they did not redact any data from that request. It also substantially raises the possibility that not public data would be disseminated. Hennepin County, in responding to what I believe was a request for 6 months of emails for certain officials, provided 8,000 emails in response for that. Even though they have staff dedicated to this function, they unfortunately disclosed not public data in doing that. They did that with staff that are full-time for data practices, review, and compliance. Most local governments don't have staff to do that. By increasing the volume of data that we would have to go through in response to data practices requests, you increase the possibility that putting out not public data it occurs, and we're both civilly and criminally liable to that. I conclude my testimony with exactly what Mr. Hilgart referenced, that the court recognized that the volume of data, the burden of some of these extraordinary requests probably needs to be addressed. So instead of expanding what has to be done, I strongly recommend that you follow the practices of the federal government and several states in either providing compensation for us for the review and redaction requirements, or allow us to review extraordinary burdensome requests. That I'll conclude my comments.
Senator Limmer.
Thank you, Mr. Carlson. Do you know the name of states that you would suggest we review their best practice policies in this area?
Mr. Chairman, I would be happy, along with Mr. Hilgard, to forward that to the committee.
And in reference to the federal government policies that you recommended, are they universally applied to every agency, or are they specific to certain ones and not to others?
Mr. Carlson.
Madam Chair, Senator Limmer, it applies to all agencies. It's part of FOIA.
Okay. All right.
I had a question for, I almost said Matt, Mr. Hilgard. You mentioned transitory, I think it was you, maybe it was Mr. Carlson, that mentioned transitory email or transitory correspondence. Could you show me where in statute is that defined? How do we get a definition for that?
Madam Chair, it's not defined in statutes. It's defined in the city's retention schedule, where I believe the 3-year standard came from that Mr. Ealing used in coming up with the author with this draft. But I may be mistaken. Ms. Pontius could correct me if I'm wrong.
Ms. Pontius, is there a statutory definition for transitory email or transitory correspondence?
Madam Chair, not that I'm aware of.
Okay. So, okay, it's in the model schedule. Okay. Okay, good. So what would your ideal legislation look like? Because right now we have a hodgepodge of different schedules out there that different government entities are using. What would you take with 1185 and change? I'll open it up to either one of you and both of you.
Madam Chair, members, first, I would defer to the staff that has expertise in the retention schedule. As was enumerated by the city representatives, their clerks and financial officers go through it annually. And I think great deference should be made to them in their recommendations. With the counties, it's more ad hoc, but currently the auditors and treasurers are going through theirs some part right now. Secondly, I would recommend that if that's not sufficient to meet the objectives of the legislature, that they create the state function that existed until 2006, I believe. Finally, if you want to go beyond that, we certainly request that you provide something for us to respond to the extraordinary burdensome request, or frankly, those requests that basically are harassment. At least 3 IPAD decisions have spoken to harassing, repeated requests. That's not captured in statute right now, but the status of the case law, if I can call the IPAD decisions, do allow us, has a basis to suggest at some point this goes beyond what's reasonable.
Madam Chair, if I could add to that too. The only thing I would add would be that there are several states that do it differently, red, blue states all across the nation, and have different mechanisms for reimbursement that include redaction, staff time associated with retrieval, search and retrieval, and redaction, and also have something in statute to help define unduly burdensome. And sometimes it allows local officials to make that decision, and sometimes there's another state agency that assists in that decision making. But there are several examples nationwide that this committee could take a look at if they're interested to see if there are good models out there.
And Mr. Hilgart, how does a person who is at poverty level or a little bit above poverty level that feels like they've been wronged by government and they want to get access to government data, how is the average person, in that situation supposed to pay for the time of redaction, for instance?
Madam Chair, that's a very good question. Again, these are just things that we're throwing out there. We want to be part of a conversation. We're looking towards a compromise or a solution that works for both sides, and it may not be perfect. Other states have models where they include a certain amount of time that is free for every request. Several states have free, no cost associated with the individual of the data. So if you're affected by it, there's no cost, period. There are different ways that you could amend that, but you're right, if it's a large request, after 2 or 4 hours, I think is the example that some states use, there would be a cost associated with the staff time.
Thank you. Any other questions? Representative Lucero.
Thank you, Madam Chair. And this is for either testifier. As I'm looking at the handout that was given here, Hennepin County is referenced several times. What are your thoughts regarding the earlier testifier that mentioned that the Sheriff's Department had a retention period of 30 days? Do you believe that that's reasonable?
Mr. Carlson.
Madam Chair, Representative, I'm not going to speak to the appropriateness of it or not. I will say that unfortunately, counties are unique in that we have several independently elected officials, sheriffs, county attorneys, possibly in some instances county treasurers, county auditors, and county recorders. Each one of them under current law is basically free to establish their own records retention schedule. If you want to create a uniform requirement, I guess you're free to do so. 30 days along with the current records retention schedule that they must have to abide by, I think frankly is sufficient. If there's some issue that can't be captured in that by the news media, then I think we're willing to discuss that, but it's unclear to me that that's really the case. Mr. Webster is an advocate on behalf of civil liberties and stuff. I, on the other hand, I'm not particularly concerned that Stingray was acquired to allow the tracking of cell phones. If my child is abducted, I sure as hell want them to have that technology to locate that individual who abducted my child, and I don't care how they went about that acquisition. But so there's a tension here, and I think the legislature will have to grapple with that.
Representative Lucero.
Madam Chair, well, I'm fighting for individual liberty as well, and I'm shocked that you say under current law, current definition of correspondence, that 30-day retention period is reasonable. That just shocks me. I took the liberty here to look at some of the private sector requirements of retention periods and private individuals. and I looked up IRS. What does the IRS, what is the retention period that they mandate us as citizens keep our records available? And there's varying, there's variables there, but the general rule of thumb is three years. I looked up back to the Sarbanes-Oxley, the genesis of the Sarbanes-Oxley, which was the Arthur Anderson Enron scandal. And that put in requirements for retention. And again, 3 years is coming up. And there are many examples where the private sector is required to have retention periods. Why? Because it's clearly understood retention periods help with accountability. And so 30 days, you thinking that that's reasonable? Again, I believe that having the 30-day retention period has such a detrimental impact to holding government accountable that has to be changed. And that's you said that we're free to change that. And that's exactly what we're attempting to do. Because I think that Minnesotans don't believe that 30 days is long enough, sufficiently long to hold government accountable. In your PowerPoint here, you mention employees are reimbursed for the use of their personal cell phones or smartphones, and that having retention periods then would cause invasion of privacy issues. Is there a policy that mandates that an employee use their personal phone for work purposes and that they be reimbursed, or is that a voluntary decision on the employee's part?
To either of the testifiers?
Mr. Chair, Madam Chair, Representative, that's a practice to avoid the complications of the county owning the cell phone and then the recipient having to, or the user of it, having to identify his or her personal use and reimburse the county for that. The counties that do that just do that for a more simple scheme to manage what is and is not official business and the cost pertaining to it.
Representative Lucero.
Thank you, Madam Chair. And I have been in many IT organizations, well, just organizations in general, working myself with an IT capacity, but organizations in general will offer that as an option. If they're in a capacity where they need to be reached after hours, they will either be provided a company-issued asset that they then need to manage and maintain and carry two phones if they have a personal phone as well, or optionally they can use their personal device and then be reimbursed. But that is a choice at the employee level. And if there's an employee that might be concerned of performing official business on the personal phone, then they would elect the option to not perform those actions and instead use a county or government issued phone. So that issue is easily remedied. Easily remedied. I see an issue here. This is just ridiculous. 209 emails, or 209 million emails to be searched would take 29 days. In this scenario that you lay out here, what's the time slice that you're searching? So if you're given search criteria, you have the universe of emails. You're looking for something specific. You can narrow it down by the keyword search, which you did here. But in this scenario, does the 209 million, does that represent any narrowing by time slice?
Mr. Carlson.
Madam Chair, Representative, the request of Webster was all 209 million emails in Hennepin County's possession be searched. And the 29 days is what they estimated it would take them, using the computer forensics software that they had, to complete the search, just to establish the population of emails that may be responsive to the term search, that they would subsequently have to go through to determine if they were clearly responsive, and then go through and review and redact. I mean, it's a three-step process.
Representative Lucero.
Thank you, Madam Chair. So based on what I have written here and based on your answer there, I'm concluding then that 209 million emails represents the entire universe of emails in the possession at the time. and it is not reasonable for any data practices request to have the expectation that the entire amount of emails be searched. That's just not reasonable. You narrow it down. That's what every person does when they're going to perform a query. They don't do the whole thing. Even if the request was to search all 209 million, you have a conversation and you use discretion to narrow it down. Not only by time slice, but also those that would be most likely be involved in the topic at hand or attempting to obtain information on. So this is just a ridiculous hypothetical. It's a scare tactic. That's what this is. Designed to dissuade people from gaining support for this bill.
Madam Chair.
Then I'll just have this one more comment here. This practice right here, I have no doubt that this does represent current capabilities that current law, I think that as was highlighted here, there's a deficiency, and that's what you're attempting to do. But when we change the law and policies change and mandates change, practices then get updated. Technologies are implemented, capabilities change to improve efficiencies. So because we change the law or make retention periods greater, it's not a fair metric to use existing capabilities, because what will happen is that will drive a series of decisions at both the department head level and at the elected officials level, whether it be city councils or counties, to begin to make changes in the practices and incorporate technologies to better serve or meet the requirements. That's what happens naturally. And in the free market system, which we have, there will be vendors that you may not even know exist that have technologies that will help you accomplish the mandates that are put down. And so I want everybody that's considering this bill to understand that this is not a point, this is a point in time. Things are constantly changing. And so while it may seem to be too much of a burden under current practices, practices will have to be updated, which is what happens all the time in IT. So thank you, Madam Chair.
Madam Chair, if I could respond, this isn't hypothetical. The 209 million emails that our representative has being requested to be searched was exactly what Webster requested and exactly is the basis of the court suit. Hennepin County did attempt to negotiate a reduction in the number of search terms. They also attempted to negotiate that they would only search the emails of the members of the sheriff's department. That was inadequate from Webster's point of view. And so the request was to 209,000 or 209 million be searched using 20 different search terms. Again, I think you can dispute whether or not 29 days is adequate. I don't think you can dispute with current technologies how long it would take to review and redact those documents that are actually responsive to the request, how long that would take. We do view this as being unduly burdensome.
Madam Chair.
Representative Lucero.
A couple additional points, and in response to that. The 209, could it be possible that the citizen demanding that, as a direct result of the non-responsiveness, the pushback, the desire to not work with the citizen, that tensions get escalated? Instead of having a county that's more responsive to the citizen's request initially, up front, being more friendly to citizens, if there was more reasonableness from the county, that maybe these demands don't necessarily have to reach this level. And then also, absolutely it's in dispute. The technologies that you're using here, forensic software, I don't know, you can take the same task using multiple technologies, you can have a wide degree of the amount of time it will take. So this is not, there's all kinds of variables that will impact this, what you have listed here. And technology is constantly changing, and I frankly, I don't have a lot of confidence in the current technology that might have been used to produce these numbers.
I'd like to bring up the next testifiers, please, if we could. Lori Byer-Kopinski and Lenora Madigan. Thank you for being here, gentlemen. Just Lori. And then on deck is Grace Kelleher. Welcome to the committee.
Good afternoon, Madam Chair. I'm Lori Byer-Kopinski, Director of Community Services at the Department of Administration. As you know, I manage the Data Practices Office as well as 5 other programs in admin. Admin and our state agency partners share your desire for meaningful government transparency, and we also take very seriously our responsibilities to maintain public records. This bill does dramatically expand the amounts and types of data that an agency would be required to retain and could diminish rather than enhance genuine transparency. I want to share with you how these proposed changes would impact state agencies. As you've heard, the current Official Records Act and records management statutes work effectively. Government agencies, as Ms. Rounds mentioned, are often in the best spot to know what their mission is, how long they need to keep their records, and how to do their work. An additional 3-year mandate on emails would add costs to each records transaction within the state. Because, as you know, you are eliminating the distinction between correspondence, which is government data, which someone can ask for, and official correspondence. And that distinction is really crucial. Government transparency has really remained fundamentally the same, and it applies to data regardless of the medium, as you've heard. But as you know, the reality is that we have a lot more electronic data and less paper. This would require state agencies to keep substantially more. And beyond the fiscal impacts, it impacts government operations by making it more difficult. When you have more data that you have to secure, it's just harder. The more you have, it's harder to secure it. Here are a few examples from different state agencies. The Department of Human Services will have not public data that they have in emails during a licensing investigation. The not public data is transferred into a complaint form, which is their official record. This bill would require them to keep all the emails with private data that are copied to multiple DHS staff people related to that investigation. Department of Education will often get data requests for aggregate data based on individual student data. And there will be emails between the IT folks, data analytics, and program staff about how to appropriately aggregate and de-identify that data. This bill would now have all of those planning emails that contain private data being maintained when really the aggregate report right now is the only official record that they have. Here is the aggregate data that we produced. Department of the deed folks, they have emails with private information from folks who are seeking unemployment insurance, Minnesotans who receive services from State Services for the Blind, as well as job seekers. And then deed staff also has non-public data on Minnesota businesses who are using state economic development programs. Unfortunately, there just isn't an IT solution that can automate and review every email for not public data. Today, I was emailing with my son's math teacher and then asked how her new baby was doing. Nothing can automate that, but there's going to be private data, a mix of both government data and not government data in every email. It's just the nature of when I can fill out a box, I can put anything in it. The premise of the existing law and a key emphasis in our data practices training is don't collect more data than you need to do your work. That's, kind of what's right for citizens. Don't collect more than you need from them, but also don't keep more than you need, because the more you have, the more you have to protect. So really, you're supposed to be able to find your data easily, be able to keep it safe, and be able to respond to data requests appropriately. And that means, I think another testifier mentioned, you got to balance how much you have with how much you have the capacity to search and deliver, because people have the right to ask for all public data or all data about them. Representative Lucero was mentioning, can't you get folks to kind of sometimes negotiate down? Sometimes you can, but we can't legally limit them. If they want to ask for all public data, we might be able to say, we can give you, like this many gigabytes every week for the rest of time, but I can't tell you, you've asked for too much, it's too burdensome. Our law doesn't provide that.
Ms. Byer-Kopinski, could I stop you there for a minute?
Yeah.
Do you think that it should?
Madam Chair, is the question whether or not there should be a limit on requests that are too large?
Right. Do you think that there should be a burdensome threshold? You're the Department of Administration that's in charge of enforcing the Data Practices Act. Do you think that there should be a burdensome, something in law for a burdensome threshold?
Madam Chair and members, I don't know if I would say on the burdensome side. I have certainly seen and heard of from various agencies, there are situations where data practices becomes the weapon, where data requests really are meant to harass government. I think that at some point it's really difficult to find a way to describe that in statute because you know it when you see it sometimes, but I think there are times when our law is being abused. Maybe appropriately, but that it's being abused.
Okay, continue on with your testimony.
Okay.
Yeah, if you could wrap it up a little.
Okay, yep. And last session, we were working to prepare a fiscal note for you and the costs. Some of the preliminary estimates on the 3-year retention would require about $1,000 per data request, depending on the size of the agency. And this estimate was really only the retrieval and the review of emails for not public data and didn't include IMs or text messages. And it also didn't include any IT or extra data storage. We're concerned that the proposal doesn't take into account transparency, ease of use, and really the resources, the people resources needed to appropriately fulfill data requests and the cost of then protecting the data. Thank you, Madam Chair and members, for being allowed to testify today, and I would love to answer any other questions you have.
Thank you. Let's hear from my, go ahead. Senator Limmer.
I had a quick question. I was listening carefully to the discussion about a burdensome request that could be considered harassment. Other people might consider it a shield to protect staff people that work for government. And I would imagine other states are wrestling with this issue or have already. Just like I asked Mr. Carlson, do you know of any states that have found the balance in this?
Madam Chair, Senator Limmer, one of the things I think to be most conscious of is most other states have a freedom of information model, whereas we're very different. FOIA provides for some broad categories where government gets to decide how much is released. Our presumption of all data is public and everyone has a right to ask for it makes it very unique. So I don't know if there are some examples from other states that might be something we could use, but I know that folks are all struggling with there is a lot more data that folks just didn't used to have. We used to have file cabinets and that was our limit.
I think the public in Minnesota might be a little further along than other states. We've grown rather skeptical of government, regardless of who runs the government and what administrations there are. I think there's been reason to believe that skepticism and suspicion is an element in how we make our policies now. And other states may have a greater trust in government. I think Minnesota has a healthy skepticism. But with that healthy skepticism, it kind of draws us out to being a point man as we traverse. And sometimes we may get ahead of ourselves a little bit, and that's why we have commissions like this to air out ideas. But if anyone in the room, if anyone has examples of a state or a government entity that seems to have gotten it right, I'd like to know. And I think it would behoove us all. But nevertheless, I'm concerned that that this type of burdensome request, whether it's a burdensome request in the eyes of the bureaucracy or whether it's a request seeking information is something that some people would consider a shield for government to hide behind. And so we're just trying to get ahead of it. The new big data world that we have entered is not going away. And it's funny how we love to collect all sorts of data as a government, but now we get very nervous about sharing our process and how to decide what to do with the information. And the very same people in government that request larger budgets, bigger computers, more freedom to collect more data are oftentimes the very same, at least departments, that are saying, don't ask me too much to share with you, the taxpayer. And I think that's where this is being motivated from.
Ms. Kopinski, was it 2003 or 2006 that the Department of Admin, how did that all happen where there was the proposal to get rid of the records management responsibility there at the department? How did that all go down? Was that a request made by the Department of Admin that they didn't want that responsibility anymore?
Madam Chair and members, the funding for the responsibility ended as a part of, I think, the 2002 budget cuts. And then the statute wasn't revised to repeal those responsibilities until 2006. So it was before I was at the department, but I understood there was just, a lot of good government programs, but there was cuts that were necessary, and that was a program that was offered up.
Okay, thank you. Any other questions for this testifier? Thank you for being here.
Thank you.
Finally, you get to play cleanup, Ms. Kelleher.
Good evening, members of the commission. I want to thank you for being here tonight. My name is Grace Kelleher, and I represent the Minnesota School Boards Association. We represent 2,000 locally elected school board members from every school district in the state. And I will do you the favor of not repeating anything you've heard tonight, but I'd like you to think about just a couple things. Education is unique, though technology is growing and we're teaching kids how to use it because it's a core function of their knowledge going forward. It is the one part of our education formula that is not funded with aid. We normally go out to the voters and ask for that. So when we talk about technology and software, it's an area where we have to go and work with our local public hand in hand to see coming forward in our school districts. We feel this bill, as it goes forward, would increase the amount of data we would have to collect. And because school districts deal with minors and their information is, shall I say, precious, we tend to be very careful about what we give out and what we store. So oftentimes when we have requests, the best way to do it, especially if you're in a smaller district, and keep in mind districts across the state range in size, is you have to call in an attorney to go through email or documents to make sure you're responding to that request in an appropriate manner. And once that's done, the redaction, because keep in mind, student information is private. We have more of that kind of private information than any other local government. So when they want to talk, people talk about storage and other issues, I would challenge you to say that when we get a request, it's that redaction cost that's expensive for school districts to bear. And throughout law, it's been clear that those are costs we can't pass on back to the requester or to the journalist who requests the information. But that's some of the struggles we go through, and I want you to think about what you want your local school districts to do. We can bring in an attorney who goes through these data practices requests and responds appropriately, or we can hire another teacher. Simply said, you need to give us our marching orders, and we'll go out and follow the law. We believe in transparency. We have more reports, report cards, accountabilities by subgroup than just about any institution. Education is trying every piece we can to be accountable. But everything comes at a cost. So as you go forward, I would encourage you, we'd be happy to work with you. We do know of other examples in other states that they've tried different things as far as these kinds of requests going forward, and I'll be happy to give you sort of a list and what the proposal is going forward, if that would be beneficial. And I'll end with those comments. Thank you, Madam Chair.
Thank you so much. Thank you so much. Is there anyone else in the audience who is wishing to testify on this bill? It's a race to the...
Madam Chair, members of the committee, it'll just be a few moments. I've been around for many years. I've done many data requests, asking for the sun, being called a harasser, being called all the things, the enemy of government. And what it all comes down to is the following. The law, which we've been under for 40+ years, is with the government for a lot of discretion. So I'm asking for everything under the sun. They come back to me and say, hey, Rich, do you need everything under the sun? Oh, maybe not. We can do a little bit. So I get something. But if I still want all the stuff under the sun, well, Mr. Neumeister, under the law, I just wanted to let you know, you're not going to get it next week. It might take a year and a half, 2 years. So I say, fine. And they do their little bit. I don't rise to the top. I'm like everybody else, anybody else. So they give a little bit. A lot of the discretion is with the government entity. That's important, number one, about the law. Number two, in regards to where the thing is that it's costing and this and that and all that sort of stuff. Again, the same issue applies, is that we're under a different kind of system here than any other law. Yes, there are burdensome requirements in their other states, but they don't get as much info as we get for public accountability and transparency, where we could find out about the stingray, or we could find out about LPRs, or some of the things you heard today. So as Chairman or as Senator Limmer said, it's a big thing, and you have to take it through some glasses and see what the current law allows for a lot of flexibility. And on the harasser, that's why we did the opinion process in 1993, where I was, and along with a couple other people, pushed that. Where there are questions, you go and get an opinion. So if you think Rich Neumeister is an harasser at government and using it, the Data Practices Act to get at you, you can say, Mr. Neumeister, we have an opinion that says we don't have to give you your data request. Then I go to court or whatever. All I'm trying to say is that, we've had the law for 40+ years. You put burdensome, you put cost, like in Duluth. They want to charge $35 an hour. After 15 minutes, it'll dry up public accountability and all kinds of things from all kinds of situations, whether it be the parent who wants to get information about their local school district and how their kid is doing, and use that as an example of things that are bad things that are happening in the school district, all the way to the Rich Neumeister, who's now in the process of asking for a lot of body cam videos and discipline records because of things I see. But a lot of people use it in different ways. I bring a lot of stuff to you, the legislator. I give it to the paper. I use it my own self in things I do. So I just wanted to sort of, we heard all these things, but I had to really share a real strong citizen and represent citizens who use this one time and they're blowing off by saying, we think it's too burdensome, but then don't know how to fight or don't know how to put their teeth together and talk or whatever. I mean, that's the important thing, the residents and citizens of this state. But I say, call out the proposals and let them come and debate. The inspection one, we had one in 1987 where they wanted to charge for money for inspection. And when that bill came through, the general example, people came out and said, testify. You're going to tell me I'm going to have to pay for government data that's mine that I already paid for because the government can't keep its records straight and do, and that proposal never happened. Same thing is here 30+ years later.
Thank you. Mr. Ealing, did you want to speak?
I'll defer to Mr. Heller, but I'd like to make just a couple technical responses to things that were said earlier.
Ms. Kelleher, did you have something else? Is that the deal?
Yes. Madam Chair, Commission, I apologize for getting back up, but this was the third time I'd heard Mr. Newmeister make the comment about school districts retaining information from parents and not allowing them access to their child's school record. That is, in fact, inaccurate and untrue. The only situation where that would occur is when a child is in 12th grade at 18. That example he has now used 3 times in this hearing really paints a tough picture about schools. I'm sure there's better examples that reflect reality we could be using other than trying to pull that one out of the clouds 3 times. So
Well, I
thank
think
you.
the one time that he spoke was in regard to the 1701, which was just finding out whom is looking at your child's records. Not that their records were being kept from, but if there's an employee, for instance, that's been looking at your child's data over and over and over again, then you should know that as a parent. That was his point. So, but thank you for coming up. Yep. Mr. Ealing, go ahead.
Thank you, Madam Chair. I'll be brief, but I wanted to address some technical issues that arose in response to some of the government testifiers. The first is that I want to challenge the idea that putting in statute this 3-year retention period that has existed for correspondence in the model retention schedules from MHS for a long time now is somehow a dramatic break from current practice. If you talk to folks that do a lot of data requests, and I do a lot of data requests, and I interact with people who do a lot of data requests, you realize that folks are asking for, as Mr. Ramos has testified, emails that are 1.5, 2 years back in time, and they're getting them. And so a lot of government entities are already keeping this kind of information already. Just in the practical reality of people making data requests, you see that. And that includes information that would be considered transitory correspondence. I've made requests for email correspondence where I get back the very kinds of things that government agencies are currently allowed to dispose of, including meeting requests by email, that kind of transitory data, I will get back in data requests, and I've seen it in a lot of other examples. So while they have the discretion to destroy it, and the bill as it's written here mimics a lot of the language that's in the transitory category as the exception to the correspondence category, so they currently have the ability to do it. They're not always doing it in every instance, so I think that's worth calling out. In regards to burdensome, and I've testified about this before in the House, but for Senate members that are here, I think it's important to realize that the idea of burden is dealt with through existing language in the Act that says that the time frame for responding to a data request is a reasonable one. And so there's IPAD guidance that says there's a rolling time frame depending on the scope of the request. And you can go back and try to narrow it to get it faster if you want. If you look at states that have imposed a statutory burdensome requirement, you run into things such as I have when I've made requests to the New Jersey governor's office. They will cite case law saying that because we have a burdensome requirement, we're not able to give you a set of emails or other information, and you can. It's hard to nail down what the scope of what they consider to be reasonable is. In states that have this requirement, so it can be used as a shield. In regard to the personal privacy concerns raised about retaining personal communications and personal devices, the Data Practices Act already contemplates that if you use a personal device to transact government business, the government information that's on that device is accessible under the Data Practices Act. So that's more of a office management protocol issue. Do you want to go down that road of maintaining that stuff on a personal device, or should you keep it on government devices? And in regards to personal privacy, there are numerous IPAD opinions that already say purely personal correspondence is not accessible under the Data Practices Act, and that's reflected in the definition of correspondence in this bill. Those are the main points I wanted to bring up, and I thank you for the additional time. I realize everyone's been here a long time.
Thank you. Mr. Heller. Can you keep your comments to a couple minutes? I've got staff here that have to go home and take their kids trick-or-treating.
Yeah, thank you again for this opportunity to speak, Chair, and Data Practice Commission.
And is this going to be right to the bills that we talked about today?
It'll be Pacific, yes.
Okay, go ahead.
My name is Rick Keller, and I officially represent the twice exceptional people with print disabilities. I come here to testify specifically regarding the information, for instance, that came from Midcoggy, 1185. Specifically, I have some handouts here I believe I'd like to provide with you, if I may. They are online, but I have a recording here because I use Adobe Reader, and I access these documents, you know, and I think it was relevant to the process because so I'm recording this meeting now, but it's the first time I'm using recording, but I'm starting to record the documents as they read out loud to me. I do access these documents for these meetings. And the handout I provided, if you're willing to take it, it's on page 17. It's online, Midcoggy, and it talks about notes and emails and searches, and I underlined the word search tools. It's critically important that this committee is transparent in making sure that the LCC makes their documents fully accessible for the public. Currently, they are not. And the LCC is not doing their due diligence. I spoke at the last meeting, which I had handouts, yet the minutes say that I unofficially represented twice exceptional, but doesn't say I've had handouts. I think that's a relevant piece to transparency. However, that's your choice if you don't want to put it in the minutes. I don't consider these handouts, these are online. Anyhow, getting back to the word searchable. Well, Minnesota Statute 16E.3 subdivision 9 requires state agencies, they create documents that are fully searchable. It's interesting as we talk about how local and state government doesn't have to follow a content accessibility law. And it's kind of disturbing because some individuals talked about interfacing technologies and how fast it can search information and sort it out for ease and use, frankly. And if they're images, you know, they're not searchable. It's going to take a longer piece. I don't know anything, frankly, that isn't born digital, other than a evaluation for a student that they have to check boxes when they do a certain type of evaluation, an observation sheet or something. But when it comes, frankly, I don't know how. There's so much that's all born digital. We're not in the paper age anymore. And if we're supposed to have best practices and transparency, let's provide universal design principles as it relates to all these words, all these bills. Do a picture, do an illustration of what we have, not just words. Have a picture over here, and then have your bills. You got to have bills. Show the big picture, what these bills are going to do, how they're going to change and create more functionality, and how we provide services for individuals and transparency. It's an important piece, because when it comes to selection, acquisition, and use, which is dedicated for teachers to look at special ed, apply that to this situation. Again, selection, acquisition, and use. By doing this, you will provide more opportunity and fairness and timely transparency for everybody. Until we include local and state, because the United States Department of Justice had to suspend rule writing even after it was written, because for e-commerce, for local, for profit and nonprofit, because they forgot local and state agencies to apply 5082, which is Web Accessibility Guidelines 2.0, which is going to become a 5.0 refresh for the state coming in January 2018. You got to consider how you make this information, again, accessible, and hold those individuals, because if Greg testified in Kiffmeyer's committee on operations that he doesn't have an accessibility policy or a continuous improvement plan, then where are we to effectively connecting with the majority of people? That's all I have to say tonight. Thank you for the opportunity to speak.
Thank you. Are there any questions for this testifier? Seeing none. Anyone else in the audience wishing to testify? Seeing no one, meeting is adjourned. Thank you for your patience, folks.